sua ki tēnei ki te mihi atu ki a tātou katoa. Kia umai ki tēnei kaupapa e karangahia nei tēnei tupuna whenua a roto kauri, ana ko koutou tērā e tirohia nei ki tēnei kaupapa. O ia no mihi ana ki te tēpu, ana ki a koe te hea mana, David, ana ki a koe hoki e mā, e whakahaere tia nei tēnei kaupapa. O tira koutou e kanohi mai, tēnā koutou katoa. Ngāti Wairere, tēnei te mihi, Ngāti Koroki Kahukura, tēnei te mihi, Ngāti Mahanga, tēnei ka mihi atu ki au koutou, e tau nei o koutou mana ki roto i tēnei hui. Nō reira e mihi. Hoi anō, ka ino i tātou. E te atua kaharawa tēnei rātou, mātou e kotahi mai i roto i tēnei kaupapa, kua arake nei ki mua i a mātou. E pai ta matua, kua nui ngā kōrero mo tēnei tupuna whenua a roto kau. Hoi anō, ko mātou tērā e kimi ana i te ara tika, i te ara pono, i te ara e whai nei i te aroha. Nō reire e pai ta matua, tiakina nei ngā kōrero katoa, a wairua, a tīnana hoki. Kia puta, kia hua mai, ana ko te huarahi e whai i te oranga. Nō reire e pai ta matua, tēnei e whakaaro nui ana ki tō tātou nei kuini, a ngā waihono i te pō, e noho i te taumata e whakaitia te motu katoa. Nō reire e pai ta matua, tēnei mātou e tuku i a mātou nei whakaaro, a mātou kupu ki a koe, i roto i te ngua tapu o tautama i karaiti. Amen.
Just check, Mr. Ryan, is Ms. Ham on her way or is she not coming at all?
No, she'll be appearing
Tomorrow?
tomorrow.
Yes. Okay. All right, well, let's deal with that in a second. Right, let's open this hearing with respect to the notice of requirement for Rotokauri strategic infrastructure, in case anybody's here that for another reason, in which case you can leave. My name's David Hill. I'm a full-time hearing commissioner and have done numbers of hearings with respect to Hamilton and Waikato over the last 15 years. So reasonably reversed on issues, including, of course, recent intensification plan changes and so on. With me is Mark, and I'll let you introduce yourself, Mark.
Mōrena koutou. I'm Mark Tamura. Many of you will know me from previous roles here in the Waikato for the Waikato Regional Council most recently, but for the last couple of years as an independent planning and strategic management consultant. Looking forward to seeing this process through with you.
Thank you, Mark, and let's just do a skeletal introduction, but before we do that, Mary, would you do the housekeeping for us, please? Just thank you.
In case of emergency, we have to visit. Do not use the lift, please. Use the left-hand stairs, and across the hall, we have toilets.
All right, thank you. Brief introductions, Lachlan, if you would. Thank you.
Yes, mōrena koutou. I'm counsel for Hamilton City Council in its capacity as the requiring authority. To my right is my associate Shay Thomas, also legal counsel. To my immediate left is Melissa Slatter, who's the lead planner for the requiring authority, and further left is Tony Denton, who is what you'd call the project sponsor from within the requiring authority team. In addition to what you see on the front bench, we've brought all of the relevant technical witnesses who have provided evidence in support of the requiring authority notice of requirement. So they're all here today and available to answer questions and present evidence. We're not entirely sure just how much or how long you wish to spend with each of the witnesses. It may be that some can come and go pretty swiftly. Others may require a little bit more time in terms of questions and exploring issues. So we're in your hands in terms of the flow of the day. The only other, I think, sort of brief sort of timing-related issue that I wanted to identify was that we have a supplementary statement, or a statement of evidence that's been, or to be presented by Joe Kukutai on behalf of Mana Whenua. And what I'd like to do with your permission, Commissioners, is open the case, call Mr. Denton in terms of the project sponsor side of things, and then, if I may, take a pause and I'd ask Ms. Kukutai to then present her statement, and then we'd get back to the flow of the Hamilton City Council witnesses, which would just be convenient for everyone if we could seek that indulgence.
Good, right, yep, happy with that, so,
Okay.
Thank you.
Thanks,
you,
sir.
Mr. Ryan, introduce your...
My name is Paul Ryan. I'm the planner for the Territorial Authority in this hearing, and I'm assisted today by Denzel Govenda, who's a planner who has helped with the project since its beginning.
Okay, thank you. And there are others around the room, and we'll recognise them in due course. I was hoping that we would start today with a conversation between Ms. Hum and Mr. Muldowney as to precisely how we're going to move, because the paper has moved substantially over the last few weeks as we've tried to catch up with where conversations have been going on in the background. It's fairly evident that there is an approach difference between council as regulator and council as requiring authority, and I was hoping we'd get some sort of direction as to where things are as of this moment. Mr. Ryan, are you able to give a thumbnail sketch as to where council as regulator currently sits on the conditions?
Yes, we are converging, shall we say, on a solution.
Parallel lines converge at infinity, so that
Yes,
doesn't give me a
yes.
great deal of comfort.
We are the Territorial Authority's witnesses will be recommending some further amendments to the conditions, but clearly the final conditions that were appended to the evidence are significantly different from that which was included with the notice of requirement. So they have gone a long way to addressing the concerns that I raised in the 42A report. So I think the comments that I'll be making are more of just some final crossing the T's and dotting the I's to arrive at a set of conditions that I would be happy with.
Right. I mean, just a general conversation at the moment. I mean, my perception is that we don't have any. I think I'm right in saying we don't have any submitters who, in actual fact, are remaining with any evidence seeking that the notice of requirement is not confirmed. I think that's true, is it?
I think that is the only caution I would bring to that statement is that I have understood in the last, I think since Friday, that Mr. Giles, on behalf of Sapphire, may wish to present lay evidence tomorrow, and it's unclear at this stage as to what that evidence will be and whether it is evidence directed at challenging the issuing of or the granting of the NOR or not. But subject to that, you're correct.
Yes, and I mean the Sapphire submission was reasonably well confined in terms of their access issue with respect to 40 Te Kauwhai East Road. So I mean, I'm taking that is a very confined opposition if that is the case. I mean, in terms of the evidence that was filed, Hounsel are no longer appearing, as I understand it.
That's right.
Newich and others, there's no appearance being entered for that. Te Rapa Gateway, Mr. Chafer, that's all sorted.
It is. Now that is a matter which is the subject of commercial negotiations which are ongoing between Hamilton City and Te Rapa Gateway, but it is all heading in the right direction. I think the only issue was that we weren't able to quite close matters out as of this morning, but Mr. Denton will update you on the position, but it is all positive.
Yeah, okay, and NZTA basically. And then we had tabled submissions, I think, from Ministry of Education, and I think that is an issue which is not closed out in terms of what the relief they were seeking, I think.
No, I'm not sure whether there's any intention for anyone from the Ministry to turn up. They certainly haven't signalled that.
There's nobody here, is there, from the Ministry of Education? Just check on behalf of no. Right.
No. So there is a sort of a hanging legal issue in relation to the Ministry's position, though, which I'll get to in my submission.
Does that mean I can get my black hat on? Is it a
Well,
hanging issue? Yes.
I'm hoping it's pretty straightforward. I mean,
Right.
they're behaving as if they have a designation and have status under 177 when
I
they
did
don't.
notice. I did note that. Yeah.
So it's just a matter of working out how we sort of continue to partner with MOE, but also respect the fact that their status is not actually as a designation holder within Rotorua at this stage. So we can explore that as we need to.
Right. And I think the correspondence from the Regional Council as of, I think it was the 3rd, is that's all, that they're satisfied. So
they are.
Provided. And then yes, we've got the statement from Ms. Kukatai, which we'll hear about subsequently. So, I mean, in terms of where we're at, it does seem to me, I mean, and this is obviously without prejudice to our decisions on this. And by the way, I should just confirm, at least I think you confirmed, that our delegation is in actual fact to make decisions on this, not recommendations. So, so it's without prejudice to that final decision, obviously. But we do seem to be focused entirely on conditions. There doesn't seem to be any technical disagreement. And Mr. Ryan, you're not proposing to introduce any technical evidence as such. It's really around the flow on from that to conditions, I think.
It's all about conditions, yes.
It's all about conditions. So, I mean, we have a couple of issues that we obviously want to interrogate a little bit further, and I can just, I guess, signal a couple of those. There's the issue of the rail crossing on Te Kowhai East Road, which obviously, given the volume of traffic that's being proposed, we just want to actually satisfy ourselves that where the requiring authority has got with that discussion is reasonable in terms of the issue. There's some understanding that I need to get a little bit further on with respect to the Greenway and the constructed wetlands and the overlap between the consent that the Greenway has and what happens if you put a designation over the expanded definition, the expanded designation footprint. So that's an issue which I just want to have a little bit of clarity on. And then I guess the other issue that we need to be absolutely satisfied is that Te Ture Whai Mana has been properly recognised in terms of the approach and the conditions. I think those are headline statements, if you like, in terms of, and then of course there's the minutiae of the conditions themselves. But I think that's, at the moment, as I apprehend it, that's a matter of which approach I think we accept is reasonable. The requiring authorities approach, which is if I can characterise it as I read it, is sort of an envelope approach with management plans recognising the uncertainties of 15 years lapse, as opposed to council who is wanting a lot more detail up front rather than subsequently, I think. Is that a fair surmise of where you're currently sitting, Mr. Ryan?
I'm a bit surprised that you're characterising the territorial authorities' sort of approach in that way.
Well, obviously we only see the papers. We don't see the behind-the-scenes conversations, yes. And it's just how it appears to look on the red lines, if you like, on the text that we've seen. Yeah. You may have advanced that further.
Certainly, we have sought bit more detail and clarity in the conditions. Clarity and certainty is a sort of a key focus of the Territorial Authority team.
Yeah, okay. So those by way of preliminaries. Mark, do you want any additional preliminaries? That by way of preliminaries. And just noting, yes, we are scheduled to do a site visit tomorrow, but that may get advanced to this afternoon, depending on where we get to over the next couple of hours, I guess. So with those sort of introductory remarks, Mr. Muldowney, I'm happy for you to open with your legals, and you may want to then decide how you want to run for the rest of the morning at least.
Just what I had intended to do was step through some of the opening legal submissions. I assume they're pre-read,
Yeah.
so I don't intend to labour through every last word, but there are, I think, some important propositions that I want to put to you, and it may be that during that presentation, if you have and Commissioner Tamura have questions, that's a good time just to explore the topic and the issue, and it may be that any questions that you have can be at least partly addressed during that exchange. So I'd be very comfortable using the opening as that opportunity, if that suits you.
Yep.
Just in terms of the presentation, we have a sort of a slide deck, if you like, of materials which may be, some of which may be relevant to various parts of the submission. So if I may get the slide deck up on the screen.
Which screen are we using?
Is she gone? No. Okay. Alex, up the back there. So we're just going to get that happening.
Yep.
And I'll explain some of those images, I think, as we go. So while that's happening, if I can just take you to the opening legal submissions and we'll work our way through it. Okay. I think we can probably start at paragraph 7, where I've set out the purpose of the designation, and obviously purpose and objectives in this context have sort of special meaning, and so it's worth just identifying exactly what the purpose and the objectives are. So the purpose is defined as securing the land and planning authorisations necessary to deliver a critical multimodal transportation and infrastructure network that will enable the full urbanisation of the Rotorkari Structure Plan area and achieve the objectives set out in section 2.4. The designation is intended to allow HCC, as the requiring authority, sufficient areas of land to protect key arterial network routes. So that's the broadly stated purpose, and then there are a series of objectives which follow. The first being in relation to the network and its function, a well-integrated multimodal transportation network, promoting a wide range of safe, responsive and efficient and sustainable transport modes. It's intended to achieve through design and improved accessibility and connectivity into Hamilton City, which is consistent with the land use spatial framework. There are wider infrastructure objectives in B1 to support the sustainable future urban land use development and growth needs in the north of Hamilton City in accordance with the Rotorkari Structure Plan, to be achieved by requiring sufficient land to protect the Rotorkari Transport Network corridor, including areas for stormwater management, whilst providing confidence to the surrounding land use development of the extent of the network. And then in B2, the corridor is, the objective is to facilitate an integrated transport system with a coherent form of intersections. It's also facilitating 3 waters infrastructure networks, the provision of key stormwater and flood management infrastructure and secondary flow corridors in accordance with catchment plans and the ICMP. It's intended to integrate with the Greenway designation for conveyance and management of stormwater and recreation connections, and the provision of other network utilities. All of that is required to be integrated with land use, and then importantly, the objective is, in terms of cultural values, to enhance the vitality of public spaces in a way that interacts positively with the multimodal transportation network and acknowledges the cultural identity of the area. So the proposed designation itself extends over 5.2 kilometres and includes the widening of 600 metres of an existing road corridor. And I might just, at this point, just take you to the first slide. So that first slide is taken from the land requirement plans contained within the NOR, and the orange outline is, of course, the designation footprint. And you can see there's obviously the north-south arterial, which runs in parallel to what is State Highway 1C to the east of it, and then there is the east-west corridor, which you can see runs at sort of a midpoint right through Te Kowhai East Road, under the State Highway 1C, and then eventually connects up with Te Rapa Strait, and that's the east-west. And you can then see there's a small sort of slightly shorter east-west connection towards the bottom third of the north-south, that there where the arrow is, which is a short extension of existing corridor, which is very much integrated with the Greenway in a way that I'll describe later in the submissions. So when we're talking about the north-south, obviously we're talking about that part of the corridor that runs in the north-south direction, and when we talk about the east-west corridor, we're obviously dealing with that mid-block east-west. I should say that most of the issues associated with the east-west is really the complexity of establishing a designation footprint in an already urbanised area, whereas the north-south is, the issues are more related to greenfields and the way it integrates with the Greenway. But we'll get into more detail about that. Any questions at that point?
Yeah, if I can, Mr. Chair, there's a slight discrepancy between this and what was filed with the NOR.
Yes.
Can you describe that?
Yep.
Just with that triangle of land, which you'll...
Yeah. So there's more to be said about this. So there's been a slight amendment to the footprint of the land requirement plans to reflect the now as-built wetlands that are associated with the Greenway. As you know, the Greenway was the subject of a separate fast-track consent process and its own designation. And as part of that fast-track consenting, there was some refined work done in terms of a number of the wetlands, and so that has resulted in a slight shift in terms of what was intended to be the land requirement plan versus basically updating it to reflect what we now know to be the state of those wetlands. That image on screen is probably, that's about as good as we can get size. So the blue outline is showing the land requirement as notified in the NOR, and what you can sort of see is the orange dotted outline is the updated land requirement. You'll have evidence from Mr. Hicks later on today, who's updated all of the drawings and the land requirement plans, and he will take you through the housekeeping associated with bringing ultimately the designation up to speed with these new land requirements. So if you have questions in relation to the footprint and so on and how that's worked, either Ms. Slatter or Mr. Hicks would be the right witnesses for that topic.
And there's no legal issue with expanding the notified designation?
No, I mean, that's firstly that there is, you have the legal ability to do that. There is tolerance, and so as a matter of law, there is no issue. The real, I think, important consideration for you would be any natural justice concerns associated with a material shift that perhaps brought into play the rights of other landowners who have chosen not to submit in the process in reliance on the original land requirement plan and are now taken by surprise by what they would now see on the screen. And so it's about natural justice and participatory rights. In this case, it's all basically affected by, well, the key party affected is Hounsell and other parties that are already submitters. So I don't consider there to be any natural justice concerns that you need to be focused on.
Are there any, and that's apropos of my question or my issue earlier, are there any issues with for Hounsell by putting a designation on top of or underneath their existing consents? Does that have any implications for them down the line?
Well,
I mean, do they then need to seek approval from the requiring authority for any works that they subsequently do if this is confirmed? Does that cut in?
They will have those matters will cut in. What I can say about that, so yes, you're absolutely right. I mean, once the designation is in place, that controls what land use can and cannot occur within the footprint. Probably what needs to be remembered is that there are development agreements that exist between Hamilton City Council and Hounsell, which facilitate all of this work in ways that meet both parties' needs. So yes, the dynamic that you've just described exists, and the answer is it's taken care of in development agreements between the two parties. You know, if there were concerns, those would be Hounsell concerns, because as we know under Section 176 and 177, the rights will sit with the designation holder. And we certainly don't have any concerns being raised by Hounsell in this context.
So just to confirm, so Hounsell are well aware of that status change?
They
basically.
Are. In fact, the status change in the land development plan amendments have been made with direct consultation and discussion with Hounsell. I
mean, it might be just for the record to get a memorandum that confirms that, so that we just bat that one away, so it's not a residual issue, and yes, it's on the record. Thank you.
I'll return to that. We'll pick that up and return to that. At 11, I just make the note that the requiring authority is seeking a 15-year lapse period. And again, that does not appear to be a controversial issue. At 12, I've talked about the strategic importance of the designation. And I'm not sure that I need to labour this. I mean, the reality is that the Rotokauri structure plan has long been a very significant, important strategic growth cell within Hamilton City. It has laid dormant in a sort of a future urban state for many years, but that is all about to change. There were obviously some very significant, what you might call gateway infrastructure issues that Rotokauri needed to confront in order to be able to achieve urbanisation. And the most important of that was the stormwater issues. It's very flat, low-lying, and does not drain naturally quickly. Existing farm drains, which are wholly inadequate to cope with the intended urbanisation, and so the Greenway designation takes care of that. And so once the Greenway designation had been confirmed and the fast track consents approved, it was really all go in terms of getting that Greenway project stood up commercially and in the LTP. And we're going to see action on the Greenway in the coming 12-month period. And then following that, with the investment that's being made in the Rotokauri growth cell, obviously the strategic transport network and all of the corridors for the other necessary services are vitally important, and that's what this designation is attempting to deliver. So in an integrated way, Rotokauri becomes serviced and given the green light. So that's what this designation is about, and that's the strategic importance really that's highlighted through paragraphs 12 through 16. At paragraph 17 of the submissions, I've talked about the site and the evolving environment, and I think that's probably one of the important things to emphasise, is that this is an environment that is going through substantial change, and so it's, I think, important to recognise that, particularly when we're thinking about consent conditions and the need for, when you're grappling with this question of the envelope effect and the management plan strategy versus a more sort of detailed and sort of locked down approach to conditions, thinking about where the appropriate balance should sit, particularly when we're dealing with a highly modified and continuing to evolve environment or receiving environment. I think I can probably press past that. I've described, I think, in part the Rotokauri Greenway, but I think it's important perhaps just to take the time at paragraph 23 to note that, so the designation was confirmed in May 2020, and there has been ongoing development planning since that time. There has been a decision granted under the COVID-19 Recovery Fast Track Consenting Act of 2020, which was a decision that issued in July 2024, and that was the fast track consents that you'll hear something about, which have enabled much of the remaining regulatory approvals to be secured. At paragraph 24, I note that.
Sorry, just whilst you're there, and I thank you for that. I missed that on my first read. So there's an existing designation of the Greenway. There is, which is a point that I'd missed earlier. So, there is. So I hadn't actually appreciated that.
Yes.
And that's not being surrendered or anything.
No, it's not.
Okay, so we'll have overlapping designations.
We will, and so section 177. That was sorry, we might have been at cross purposes slightly.
Yeah, no, it was my obviously my understanding was not complete, so that's helpful. Thank you for that.
So that will take care of that, and I should say that the development agreements that sit in the background are still relevant and will take care of how those rights are adjusted as the project is built. So that's that. At 24, I think I note there's the slight adjustments to those wetlands, which we'll talk about shortly. In terms of timing at 25, I've noted that the construction of the Rotokauri strategic infrastructure. So just to be clear on some terminology here, there has been. This project has been variously described as the Rotokauri arterial designation, but I think as we've moved a little bit further in the process, there's a concern that descriptor is a little narrow because it sort of carries with it connotations of simply a transport-only corridor, but it is very much an arterial corridor, but it's providing integrated infrastructure in terms of the three waters and all the network servicing and so on. So you'll see various descriptions, but when we're talking about the Rotokauri strategic infrastructure project, that's this.
Can't help noting that RSI has a different meaning for me.
Yes, yeah, no, there was that, but we pressed ahead nevertheless. RSI it is. The point at 25 is that the construction of the Greenway will span several construction seasons involving significant bulk earthworks and associated effects, which will be managed by a suite of designation conditions, resource consents and management plans. And the existence of the Rotokauri Greenway and associated wetlands has been assumed in all effects assessments relating to the NOR. And I'll explore this point a little bit further in the submissions about what I say is the correct approach to the assessment of effects, because as will be familiar to both of the commissioners, we do have this Hawthorne approach to the receiving environment and some assumptions that need to be built into what you consider to be the receiving environment. It's not just what you will see today or tomorrow on your site visit. It's that overlaid with some other projects which, as a matter of case law, you would need to sort of layer up in what you consider to be your receiving environment. We'll talk about that a bit more.
Just a couple of little questions about this timing and the relationship between the two designations. First of all, I noticed in among the papers, there's a condition in the Greenway designation that requires a particular alignment for a piece of for a section of overland flow path that's, from what we've seen, unable to be achieved in light of further investigations. Perhaps more a matter of curiosity, but do any issues arise when the solution arrived through here offends a condition imposed by the other designation?
I think I'm going to need to reflect on that. I'd like to study the condition that you're referring to. I mean, there will be ways that can be addressed. Obviously, the Section 177 rights that will be brought into play, will be relevant here. So the holder of the designation of the Greenway, which is first in time, to the extent that there's any overlap, they will have the ability to control and veto what may or may not occur within the footprint of their designation. So that might be part of the answer.
So perhaps the point the pointy end of that is really the extent to which that solution, and we weren't part of that process, but the extent to which that solution was critical in achieving the balance of effects for that process. And I guess we would get an understanding of that if we had some confidence that condition was able to be varied.
Yes, I understand the point, which is that while there might be the legal mechanism to deal with the issue, the planning concern is that the two designations have just got some sort of mutually exclusive outcome here that can't be reconciled even with the rights adjustment which occurs under Section 177. So you need some confidence that it can be solved, not just that there's a mechanism to solve it, but confidence that it can be solved.
That would certainly help me. Yeah. I do have that condition somewhere. I'll pull it up later. We can continue. But I had another related question, which again, perhaps we'll come to it. And if we are to come to it later, that's fine. But it was in relation to the that point 25 in your legal submissions, and I know there's been quite a lot of back and forth around these conditions which relate to precisely that issue, the timing. and how that manifests in the conditions. It doesn't appear that there's any disagreement about the material importance of the Greenway and its functions being accessible to the transport or the RSI corridor, but somehow that's manifesting in a difference in approach to the conditions we're not seeing much movement on. So I guess we'll come to that later, but I do think it's important just to note that there doesn't appear to be any disagreement over the criticality of the function of that accessible. That's what I'm seeing in your legal subs, right?
That's right. Okay, well, we'll thank you for the signal. We'll pick that up with the right witnesses as well and make sure that you get the answers you need.
Thanks.
Just to be clear, and presumably 25 just accepts that the Greenway corridor will be built in stages as well, and that obviously there's a dovetailing that needs to go
on. At 26, I talk about the wider receiving environment, and I think the point there is that there are some fairly significantly advanced master plans for large greenfield developments within Rotokauri, so urbanisation is very much underway. All of it, however, is contingent upon the Greenway being built in stages so that there can be a sort of an incremental rollout of residential land use as the Greenway itself is rolled out. I think we can probably go through to 28, which is really starting to develop this point about how do you approach the receiving environment. So the predictions regarding the future state of the environment are important because they help frame the effects assessment and the consideration of the effects of allowing the NOR under Section 168A3 of the RMA, as is well understood. The necessary starting point for the consideration of the effects is to understand the relevant receiving environment. So Hawthorn is obviously the leading authority. This is uncontroversial, and it basically provides that determining the environment embraces the future state of the environment as it might be modified by the utilisation of rights to carry out permitted activities and implementation of resource consents where it appears that those consents will be implemented. So a designation can be set for within the first limb being akin to a provision in a district plan for a permitted activity. A designation has the effect of not allowing anyone to undertake any activity that would prevent or hinder the designated works without the prior written consent of the requiring authority which holds the designation. It is to be included in a district plan as if it were a rule, and the High Court has held that irrespective of which limb of Hawthorn is engaged by a designation, what is required is consideration of the permitted uses which may occur in the future through a pragmatic or real-world lens. The as-yet unimplemented subdivision and land use consents held by landowners and developers, which in part rely on the construction of the Rotokauri Greenway, fall squarely within the second limb, and on this basis the relevant receiving environment against which the effects of the NOR must be assessed must include the Rotokauri Greenway designation and its associated resource consents and those unimplemented subdivision and land use consents. On this basis, and for the purpose of any effect assessment, the environment is not simply what can be seen today, but what its future state is likely to be once these various land use rights are implemented. In accordance with this legal position, the assessment of environmental effects set out in Section 8 of the NOR was prepared on the basis that the Greenway corridor is underway or completed and degree of urbanisation is occurring at the time the Rotokauri strategic infrastructure construction commences, and the technical reports are all based on that state of the receiving environment. The evolving nature of the receiving environment is an important factor to consider, particularly in the context of a designation with a 15-year lapse period. In deciding whether to confirm the designation, the panel must be satisfied that its consideration of the effects on the environment of allowing the NOR remain reliable into the future. This requires a degree of flexibility and adaptive management to be built into the conditions of the designation to ensure that the environment, as the environment changes, the detailed design of the project can evolve with it to ensure that no new adverse effects or effects not previously considered arise. I just want to pause there. I mean, that's quite critical here, that we think about what are we actually driving at, you are going to be called on to make some decisions about the effects of the project, and your assessment of effects will take into account this future state of the environment. We then need to make sure that the conditions that you impose have the flexibility to ensure that the project can sort of move with and respond to the future state of the environment. And that's obviously what the management plan strategy does, and the sort of the envelope effect will deliver that. But you also need to be satisfied that you don't find yourself in a position where there are new effects that haven't been considered by you. And that I think is that's the piece that you need to be cautious of, is this idea that there's something about the effects assessment or the conditions that are being promoted that might leave stakeholders in a position in 15 years' time where the project is implemented and there's a new effect that just was never addressed or assessed or is incapable of being addressed through the management plans, because that would be effectively a blind spot that hasn't been adequately dealt with. And what we're saying is that the flexibility in the management plan approach and the way that the conditions have been approached ensures that that doesn't occur.
Just thinking about that, I mean, doesn't that cut against the requiring authority if you allow for new effects that are not contemplated today to be required to be considered in 15 years' time through the management plan?
Sorry, maybe I've not articulated myself right. That's exactly what we want to avoid.
Yeah, that's what I would have thought.
The idea of these fresh effects assessments. Yeah. The point is that the effects that you are assessing today need to take into account the future state of the environment. But there are assumptions that are being made. You know, it's not perfect. It's not as easy as simply seeing what we see on your site visit. There are assumptions to be made. So you need to be satisfied that the management plan approach will have enough flexibility to deal with any vagaries in those assumptions. But what you can't, and that needs to, you need to get to a point where you're satisfied that all potential effects have been addressed. But you can't find yourself in a situation where we do an effects assessment today and then we have to do some kind of brand new fresh effects assessment in 15 years' time.
I mean, what I'm thinking about, of course, is as we're experiencing with the current government, new national policies and so on could well come through. You're not proposing that in actual fact those management plans would then need to open themselves up to anything new that comes through from central government, for example. No.
And that I think is one of the issues that I would ask the commissioners to engage with in terms of where we get to on conditions, is making sure that, you know, when ultimately the requiring authority moves to detailed design and the outline plan process, it's not being required to do it all again. So I think we could probably move to the legal and planning framework. Obviously at 36 I've set out 168A, which is the relevant part of the Resource Management Act where which anchors your decision making. And then I've made some legal submissions which really are addressing how to interpret and implement those legal tests, if you want to call them that, or criteria, I should say. Probably at 38, I can pick it up and say that the evaluation calls for consideration of the effects on the environment of allowing the requirement, and that is a consideration which is subject to the provisions of Part 2 and other relevant policy, higher order policy statements. So the evaluation of the NOR must also have particular regard to whether adequate consideration has been given to alternative sites, routes or methods and if the requiring authority does not own or control all of the land necessary to give effect to the designation sought, which is the case in this instance. And additionally, the evaluation must consider whether the work and the designation is reasonably necessary for achieving the stated purpose or objectives of the NOR. Next, I sort of really developed this point about the effects assessment, and I think probably what's important about this section is really this statement which is made in paragraph 43, where I've taken an excerpt from the High Court decision in Queenstown Airports, where it said that at 68, it will be seen that the focal point of the assessment is, subject to Part 2, a consideration of the effects of allowing the requirement having particular regard to the stated matters. The import of this is that the purpose, policies and directions in Part 2 set the frame for the consideration of the effects on the environment of allowing the requirement. Indeed, in the event of conflict with the directions in Section 171 or 168 in this case, Part 2 matters override them. And there's some further useful comments made in paragraph 69 and 70 of that decision, which I won't read, but you can read for yourself. The other, I think, important piece of this part of the submissions is at 45, where I say that in regarding Part 2, in relation to the Board of Inquiry decision on the Basin Bridge project, which is that was the flyover, the Board observed that the reference being subject to Part 2 did not entitle it to ask whether some other project alignment or design better meets the requirements of Part 2. The Act does not direct a particular use or require the best use of resources. All that's required is a careful assessment of the project and of itself to determine whether it achieves the RMA's purpose. And at paragraph 46, I've just developed that point to say why delivery of the project does deliver on ultimately the sustainable management principle, which is at 46. At 47, I've just done a bit of a pass-through of what I say are the relevant higher order policy and policy statements and statutory instruments, which I can take as read. They'll be familiar to you. And we can probably move to 50, which is just zoning in on this assessment of environmental effects point. And at 50, I say that once framed by these Part 2 RMA and higher order policy considerations, the effects of allowing the designation must be assessed. Critically, the RMA does not call for a no effects outcome, and nor for an outcome which ensures adverse effects are controlled so that they are minor or less than minor. Indeed, many designation projects are confirmed where, even once conditions are imposed, a significant residual adverse effect remains. And a really good example of that was the Board of Inquiry decision on the Upper North Island grid upgrade project, which is the big Transpower, A-frame electricity towers that span most of the Waikato, where the court or the board said that despite concluding the project was authorised, even with mitigations proposed, the project would still have significant landscape and visual effects on the environment, and also cumulative effects on the effects on existing transmission lines. It would have significant potential adverse social effects and substantial adverse effects on the management of land for farming and other businesses. But in weighing the effects in its overall judgment, the board concluded that, and I'll read this, the board has to compare the significance of those adverse effects taken together with the significance of the national and regional need for and benefit of the grid upgrade project. In evaluating the grid upgrade, the board gives effect to the way and rate in which the proposal would enable people and communities to provide for their social, economic and cultural well-being and for their health and safety, and for the meeting of reasonably foreseeable needs of future generations, and to the many respects in which the project has been designed to avoid, remedy and mitigate adverse effects on the environment, although in the result not all adverse effects have been eliminated. The ultimate criterion is whether allowing or declining the designation requirements and resource consents for the grid upgrade project would more fully achieve the sustainable management purpose of the Act. And on that criterion, the board judges that allowing the grid upgrade project, even with its failures of full protection from inappropriate development and its considerable actual and potential adverse effects, would more fully achieve the sustainable management purpose described in Section 5 than would declining it. It follows that the requirements should be confirmed and the resource consents granted, in each case subject to the proposed conditions. So that's a pretty stark reminder that, you know, we're not in the game here of getting all of our effects down to some threshold point of minor or whatever. When we're dealing with designations and infrastructure projects of this nature, it can be acceptable in the round to have residual adverse effects if stepping back and giving an overall judgment, you can be satisfied that confirming the designation better achieves or best achieves the sustainable management purpose of the RMA. Now, I say that...
And I think that's, I mean, you've commented on that, but that's in large part because the only injunction on us is to have particular regard to all of those matters, not to actually adopt them or to implement them or whatever.
That's right. And we you know, we're not in a legal structure where there is some sort of hard edge requirement as to what, you know, what level of adverse effect is acceptable or not. You know, we're not. This is not a Section 95 notification type process. So, as I say, that's important. The
Little question on that though. That is with some edges though, right? Because where there's a higher order planning instrument that does prescribe an avoidance of or the likes, that is to be. Can you just help me out with how, in respect of designations, the landscape may differ to other resource management environments when it comes to some of those directive policies and national instruments, which we saw really shake up the system post King Salmon?
Well, firstly, that the words in Section 168A, subsection 3, are that when considering the requirement, you must, subject to Part 2, consider the effects of the environment of allowing the requirement, having particular regard to. So that's the magic sort of phrase, having particular regard to. And so that would be the first thing. The other point, I think, which is perhaps what you're driving at, Commissioner, is where we're dealing with hard-edged policy provisions which do require avoidance of particular adverse effects. How do we reconcile that with what I've just said? And you're right that those, if there are hard-edged policy considerations of that nature that are calling for avoidance, you would have to have regard to those in your overall evaluation of the effects of the proposal, but it wouldn't necessarily culminate in some kind of ultimate veto. So that would be my submissions on that point. The other submission I would make on that point is that in this particular situation, I don't consider there to be any hard-edged avoidance principles sitting in those higher order documents that take you into that territory in this particular situation.
And of course that's subsequently modified with the requirement for material harm to be the threshold as well. It's not an absolute avoidance. Yeah.
So I think that's probably, we can move, I think, through this section fairly crisply. The only, probably the only other comments I just want to make on this topic are, firstly, just to close out, that even though I emphasise the legal position and that there can be, you know, residual and adverse effects which may be significant, but it still doesn't count against confirmation of the designation. We are not in that territory here. So that may be your legal threshold test, but I can assure you we're not pushing up against that. We do not have an effects assessment that is suggesting that there are significant adverse effects which are residual, and so I don't consider that we're, as I say, pushing up against that point. At the other end of the scale, I do want to just make the point that there are at times some comments in the Section 42A report about effects being managed to levels which are minor or no more than minor, and again, I just want to emphasise that that is not a threshold test that you need to meet or consider. And I think that you can test this with all of the witnesses, but they would, I think, all of the witnesses for the RA would confirm that effects are being managed to the appropriate levels. Whether you consider that to be the case is obviously a judgment for you to make, but there is no suggestion here that we're running up against either at one end, A, significant adverse effects, nor are we necessarily having to meet a test of less than minor or something like that. But again, that can be something you can test with witnesses. The second, once we move past that effects assessment, the second major task for you as commissioners is obviously to be satisfied that there has been adequate consideration given to alternatives. And again, I don't know that this is particularly controversial, so we can probably take most of this as read. There was, I think, I made one point in the submissions about the original Section 42A report, which said that they were not or could not confirm that the test of adequacy of alternatives had been met because the effects at 40 Te Kowhai Road, the internal effects, site effects, hadn't been fully evaluated. And I made the point in my submissions that, well, I feel like we may be starting to conflate effects assessments with adequacy of alternatives. And the point I make in my submissions is that when you're dealing with that legal test of has there been consideration, adequate consideration of alternatives, the threshold that you're really looking for is, as I've said in 64, you haven't acted in an arbitrary or cursory manner in the consideration of alternatives, but we would say we have carried out a robust investigation of alternatives, and you can be satisfied that that particular part of the test has been met. There's a pretty useful excerpt again from that North Island grid upgrade Board of Inquiry decision, which I've set out at paragraph 57, which is really just setting the standard in terms of an alternatives assessment, and we would say we comfortably meet that. So I think that any concern that there was about the adequacy of the alternatives assessment, I think, has been addressed, and I do note that in the addendum 42A report they appear to confirm that. So I think that issue has fallen away. As I say, I have heard that Mr. Giles from Sapphire does intend to come to the hearing tomorrow morning, and I'm not sure, as I say, there's been no expert evidence presented by him, and I'm not quite sure what he has to say. But I will, I think, just explain the legal position as I see it in relation to Sapphire, because I think it would be good to set the frame for that if you are going to hear from Mr. Giles tomorrow. So I'll get to that in a second. Just dealing with submitters, at 73, there were a total of 18 submissions lodged. Watson Land and Alcock have been withdrawn, and Sago was struck out. There has been ongoing engagement with submitters. There's been active discussions and exchanges between most submitters that were prepared to, and my submission is that the fact that we have a pretty low submitter turnout indicates that there's been a good degree of success in resolving submitter concerns. At 75, I've just worked my way through each of the submitters, and again, I probably can take this as read. I'll address submitter 2, Sapphire, in a little bit more detail with you. Regional Council has provided its letter of the 1 October confirming it's comfortable with the RA's final set of conditions. Mr Denton is going to give you a brief update on where Te Rapa Gateway has got to. I think probably the rest of it we can pretty much just take that as read. That final submission 17, the Ministry of Education, as I say, I think probably the key issue from the requiring authority in relation to the MOE is really the fact that they clearly have intentions to make some kind of strategic investment in the Rotorua structure plan area. That makes perfect sense, but they haven't yet identified a site, sought a designation and secured the rights that they would otherwise have under Section 177. So, look, the short point is that the relationship between the RA and the Ministry is a positive one, and we will continue to engage with them and make sure that their needs are being addressed and accommodated as best we can. But until they have status as a designation holder or have sort of declared their hand in terms of a preferred site, an identified site, it's a bit difficult.
Well, Downey, the rights conferred under Section 177 exist whether or not there's a condition, right?
Yes.
They're there.
That's right. Yes. All right, so I think we can move past that, and just, as I say, I'm conscious of time, so I don't want to unnecessarily hold you up. At paragraph 105, I've identified some key legal and planning issues. So one of the important issues that is already starting to emerge as a bit of a theme in this discussion is the other relevant designations and the interface or the relationship between the other designations, and I just want to speak briefly to that. So the first is obviously the transport designations that are held by the New Zealand Transport Agency. So we've got obviously State Highway 1C. So up again on the image, you can see that that's State Highway 1C that's running north-south immediately to the east of the proposed designation, and then there is also State Highway 39, which is just where the proposed designation terminates Te Kowhai Road. There's just the beginning of an intersection with what is State Highway 39. So there's an interaction there, and then obviously there are interactions further down the route. Importantly, the crossings, each of the two crossings that you see where it's Te Kowhai and Chalmers Road, those are existing underpasses. So those were future-proofed back when 1C was first constructed. So we're obviously running the designations underneath State Highway 1C. The intersection with 39 is going to be a sort of an interchange, which I think is a roundabout proposed, where those two will overlap to the north. And again, as you can probably see from the engagement that we've had with NZTA and their lack of any sort of real enthusiasm as an active submitter, there is general support for what's going on. They're comfortable with the intersection and the treatment, comfortable that they have those rights that Commissioner Tamura, you've identified in 177, So it's just a matter of making sure that they are appropriately taken care of as a stakeholder in the various engagement processes, but relatively uncontroversial and uncomplicated in terms of the relationship between the NZTA designations and what's being proposed. Slightly more complicated might be the Kiwi Rail North Island Main Trunk Line designation. So again, if we just come back to that image on the screen, this is an issue in relation to the east-west arm of what's being proposed. You can see that it crosses the North Island Main Trunk Line just, well, I mean, you know where it is. It's just to the west of Te Rapa Road. And there is an existing level crossing on Te Kowhai Road East currently. And so what we are proposing is that level crossing be upgraded and improved as part of the works. The issue with this designation is that there is a deed of agreement that exists between Hamilton City and Kiwi Rail, which has recognised that this level crossing will require some form of upgrade to a four-laning with pedestrian treatment, etc. And that deed of agreement is included within the NOR materials, which is a sort of a broad, I guess, acceptance from HCC and Kiwi Rail that there is more to come in terms of this level crossing, and that there will be an upgrade of some sort required in the future. There's been a lot of work done in terms of the safety analysis and the optioneering in relation to this particular issue. And Mr. McQueen, who's an experienced expert in this field, will provide evidence for you on what's gone on. But there is, in short order, what I would say is this: there is, within that optioneering, consideration been given to terminating level crossing altogether. The costs associated with that are deemed to be totally disproportionate to the risks and benefits associated with that. And so the analysis that has been completed brings us back to level crossing, but significant improvements to be made, particularly in relation to safety and in relation to pedestrian and cycle treatment. The draft conditions, again, have an advisory note which we say will bring Kiwi Rail and Hamilton City as the requiring authority together at the right time during detailed design to get the appropriate treatment confirmed and agreed. And once again, 177 bites. Ultimately, if we can't get it over the line with Kiwi Rail, those rights prevail, and there are appeal rights associated with decisions around 177, but I think the key point is that there is a mechanism to ensure that to the extent that they are competing interests, they ultimately will be reconciled. Again, Mr. McQueen is the expert in this field. He's highly experienced, and if you have technical questions and matters that relate to rail generally, he's your witness.
I assume, I'll ask the question, I assume that if in actual fact grade separation does become the option of choice in 15 years' time or whatever, is the designation at this stage wide enough to cater for that, or that will be a separate process?
We're into blue sky thinking at that point. I mean, if this got to the point where, for whatever reason, grade separation was necessary, this is not the designation which enables grade separation. But again, as Mr. McQueen can attest to and give evidence on, the analysis that has been undertaken in terms of the safety work, there's a formula, there's a sort of a whole matrix of considerations and grade separation and the benefits.
I'm really suspicious of formulae.
Well, I think the point is this, that when we're dealing with the risks associated with an at-grade level crossing, they are obviously real and need to be managed through good design. The question really is, can that good design get us where we need to get to in terms of an appropriate treatment of risk, or do we need to start thinking about grade separation? And the risks and the costs and benefits associated with all of that need to be evaluated, and the clear conclusion is grade separation it's overkill. It's not necessary. Now, Kiwi Rail, I think, would love to have a network which operates with grade separated crossings throughout the country, but that's just not our reality.
Yeah. Yeah, and we can ask questions later on. I mean, one of the things that occurred to me, and I will have a look at the site tomorrow, is just anticipating the future development in that particular area. There is a degree of openness at the moment there, but that will close, obviously, as development happens, and whether in actual fact the risk assessment actually has anticipated the development that will go on in that area as part and parcel of, in terms of line of sight and so on.
So, sorry, when you say the area, are you talking about the direct,
The immediate area.
The immediate area,
Yeah,
yes.
the immediate
Well,
area.
again, that I think is something that can be explored with the witness. Probably the key things that need to be thought about there is, first of all, you can see immediately to the south there's Tasman Road, which intersects with the east-west arterial. Tasman Road, ultimately, my understanding is that there will need to be signalisation to control that intersection. The other main feature of what is proposed is that the existing entranceways onto 40 Te Kowhai East Road, which is just immediately to the north and slightly to the east of that Tasman Road intersection, are proposed to be closed and redirected. And so the thinking that has been done is that by controlling those entry and exit points, controlling the intersection at Tasman Road with the intended upgrading of the level crossing itself, we have all the footprint we need to produce a safe and efficient piece of the network. But again, there's witnesses that you can explore that with. And then finally, the other significant designation is, of course, the Rotokauri Greenway corridor, which we've discussed in some detail. And this is obviously, an important factor. So up on the screen there is probably the best illustration. That document comes from, what's its provenance, Shane, that one? That comes from Appendix B of the NOR, so it's some stormwater related material, but it's pretty useful just to show you the sort of spatial relationship between the RSI on the one hand, which is the red lines obviously, and then you can see the Greenway corridor is the blue, which is running again in a sort of a north-south direction, but then ultimately bears west as it discharges to Lake Rotokauri. And that shows you the sort of spatial relationship, and obviously in that section, just where the cursor is now, just sort of between that and south is where some of those main shared wetlands will be located. And then the other point I was going to make was you can see the intersection there of the Chalmers Road crossing where it crosses that right there, you can see there. So that's Chalmers Road. Firstly, it crosses underneath the State Highway 1C, but then you can see it also interacts pretty directly with the Greenway and crosses the Greenway. This is a lot of interconnectedness in that sense. And part of the fast-track consents for the Greenway actually dealt with some of the regional consents associated with getting that part of the road built, because there was a whole lot of earthworks and stormwater-related matters that you simply couldn't separate out. You had to, if you were going to consent the Greenway, you kind of needed to deal with some of the issues associated with forming and extending the arterial. So it's just an illustration of the crossover and interconnectedness. So that's that. Then I've at paragraph 127, I've addressed the issues with the Waikato Tainui land at the boulevard. And we'll just bring up another image just to show this. So this is an image of the land requirement plan right at the far eastern section of the east-west arterial. It's kind of in a north-south orientation, but it actually runs east-west, if you can figure that. And so if you look, you can see there's a triangle. That triangle that's being made out just there. You can see that triangle is not part of the land requirement plan. But you can see that it does in fact accommodate the underlying existing Mahanga Road extension and that roundabout. And with the proposed works under the designation, that roundabout intersection will be further upgraded and expanded slightly in terms of necessary footprint. And ordinarily, seeking a designation, we would need to make sure that we've got all the land we need to complete the works. In this case, we have not sought to designate that triangle because it is Raupatu land and it is readily recognised by Hamilton City Council as being culturally insensitive to secure a designation over that land, particularly when it carries with it Public Works Act compulsory acquisition type rights. So that is an important factor in terms of the land requirement plans. It does not include that section for those cultural reasons. And that would ordinarily leave you as commissioners in a slightly interesting position, because you're now grappling with, well, how do we give effect to this designation when there's a piece missing? And the answer is that with the goodwill and the partnership relationship that Hamilton City has with Waikato Tainui, there's been an acknowledgement from Waikato Tainui that they will accommodate a land use resource consent which would be necessary to complete the works so that it encroaches into the triangle of land. And so the notice of requirement includes as one of the appendices the relevant letter that has been written on behalf of Waikato Tainui. It's, I think, has come via Tainui Group Holdings, which is obviously the operational arm controlling the base, which is a significant asset. But again, that letter makes it very clear that the approach that's been taken by Hamilton City Council is appropriate from its perspective, and that it was comfortable with the idea of accommodating the works on the land when necessary. I think included within that letter there's even some attachments which include the basic form of the works that's proposed as part of the designation, so that there's no surprises. That's the triangle, we've seen that, thank you. And I think if we keep going past the title, keep going, we get, yeah, so that's some plans showing a basic, just scroll back slightly. Yep. So that's an attachment to that letter, which is recognising the land requirement plan and what the proposed works might look like if it was to encroach, so that everyone's on the same page and there's no surprises. So, I just pause there and just check, are there any questions around that? I mean, hopefully makes perfect sense, but happy to deal with any questions.
Yeah, no, my only question on that is the, what am I looking at? I'm looking at the land requirement sheet 6.
Yep.
And it shows an area there, a right-of-way easement. Just explain what the right-of-way easement is.
Yes, so...
Because that's overlying the same area of land, isn't it?
There's an existing easement, which... So the land is owned in the name of Potato de Wherewhero, so we've got that as the ownership. It's then, I believe, part of an easement to Tainui Group Holdings. There's some control that Tainui Group Holdings exerts. Then there's Mahanga Road, which is, if you drive out there on your site visit, you'll see it looks and feels and reads like a road, as a public road, but it's in fact a private right-of-way or a public right-of-way, which enables connection through to the northern end of the base. But as you drive down it, it looks and feels and operates as a road. But it's in fact authorised through a series of easements and right-of-ways.
So the same principle was applied at the time, I take it?
Yes, and so you'd expect to see something similar being sort of recycled, but to recognise the new layout that the work proposes. So it would be a combination of things occurring. One is resource consent, land use consent for the work on the property, and then access ownership issues being resolved through rights of way and easements and so on, so that it functions as a public road. But ownership itself does not change.
Yeah, yeah.
So that then moves us to the access issues at Te Kowhai East Road. We can probably, I'm wondering if we can stay with the same building or if there's another drawing. Yeah, that's pretty handy. So just where the cursor, you can see there's that orange strip. That's the main trunk line running north-south. So that's that intersection that of the level crossing there. You can see this is being depicted as a 4-lane level crossing. So you've got Tasman Road intersection just immediately to the west, and then you have 40 Te Kowhai Road as the property immediately north of that. And that property currently has a series of entranceways in and out of its property, which are utilised, and it is intended that those existing access points be terminated when the work is implemented. And that of course gives rise to both legal issues in terms of landlocked land, but also it gives rise to potentially significant adverse effects for the owners and those that operate within 40 Te Kowhai East Road. That issue is being resolved through the designation, through the creation of an alternative access point for Te Kowhai East Road, which will bring up another image to show you that. Yep, if you just keep scrolling, that one could work. Just go back to the image that you had, Alec, if we could, please. And then we'll get to these, but I just want to go back to that first image. Yeah, no, next one. It was the slightly wider view. No. the one showing the cul-de-sac which is going to be created, which gives it the access. Yep, that one there. Can you just scroll? Yep, that's fine. So you can see here there's Tasman Road, and you can see 40 Te Kowhai Road there with all of the buildings opposite it. And you can see just immediately to where the cursor is, you can see that there is a proposed, within the footprint of the designation, you can see that there is the head of a cul-de-sac which is to be created as part of the designation works. And so that cul-de-sac will be delivered as part of the work, and off the head of that cul-de-sac there will be an entranceway onto 40 Te Kowhai Road. And then if I scroll, or sorry Alec, if we can just bring up some of those other images. There have been a series of sort of tests done which identify heavy traffic movements through the site. Those are the heavy traffic movements associated with the existing connection points, and you can see where the heavy trucks move around the site based on those connection points. And then there's been some analysis done as to how those internal movements can be facilitated through the new access way off the cul-de-sac, which I'll bring up. So this has been again tested and satisfied that the heavy traffic movements can work in this way within the site. And I think there's a couple of other images showing similar testing. So the point about Te Kowhai East Road and the concerns that there are about the change in access is that firstly there will be, dealing first of all with the reason for this. The reason, if we go back to sort of square one, firstly in terms of the level crossing upgrade and the queuing associated with the level crossing upgrade, having those existing access ways continuing to operate within that new environment doesn't meet any traffic engineer's idea of safety and efficiency. Those concerns are then compounded by the Tasman Road intersection to the immediate south. So the overall sort of net effect really is that from a safety and efficiency perspective, those existing access ways cannot be reconciled with what is being proposed here. So they need to be terminated. That immediately gives rise to the issues that I've described, and so those are being addressed and mitigated through the cul-de-sac, which is part of the works that are being approved through the designation. And so the alternative access ways, and there is a condition in the designation, proposed conditions, making it very clear that the termination of those access ways does not occur until such time as the alternative is in place. So that is the practical way to deal with 40 Te Kowhai East Road. There are, I anticipate, concerns potentially around, well, what does it mean for their internal configuration, and there's a multitude of leasehold arrangements on the site, and what does it mean? Those, I submit, are matters that are not for this forum. And the reason I say that is that, first of all, you need to be satisfied at a threshold level that there is access, alternative access being provided, and that it is practical and reasonable. Ultimately, if the new access way creates problems for tenants or extra challenges in terms of moving around the site, and we say it doesn't, but let's imagine it does, those are matters which are the subject of compensation under the Public Works Act. So there will be valuations that need to be undertaken to determine what impact this new access has on tenancies? Are there, for example, some tenancies which need to terminate? What cost might that then present to the landowner? All of that then gets factored into a valuation exercise, and the requiring authority needs to make the landowner whole. Now, exactly what that might ultimately look like is a question for the future, we say, and it's not a matter that you can resolve within your powers and functions in this forum. But what you can be satisfied of, the matters that you can be satisfied of, is firstly, the significant adverse effect which arises from termination is being addressed directly, and it's being captured in a condition which makes sure that it is addressed ahead of the effect occurring. That it is practical and reasonable, and that to the extent that there are any other concerns or costs visited upon the landowner as a result of this new access way, the Public Works Act is the mechanism to deal with that and make the landowner whole.
And just to be clear for me, so the Public Works Act can be used in this instance even though you're not actually taking that land?
It can, yes. There are Public Works Act compensation provisions which obviously deal with land being taken, and there are other compensation mechanisms which address where land is
being
not
affected.
taken, but you are injuriously affected.
Yeah, okay. And I was going to ask whether they had been party to the circulation diagrams that had been worked through, but I'm intuiting that that's not the case.
Yeah, I think there may have. I mean, again, that's something that we can clarify. There has been direct engagement, but there hasn't been engagement for some time. So it may be.
And I think I saw a note in someone's evidence the fact that they declined involvement at some point.
Yeah. But that's only more recently. There has been engagement up until a point. All right, so that I think is the issue with Te Kowhai, 40 Te Kowhai Road. And then I think finally, just in terms of issues, is really the topic of cultural engagement. And you will have apprehended that the cultural effects and the management of cultural effects has been a matter which is seen of great importance to both the requiring authority and the territorial authority in terms of the 42A reporting. The short point here is that the requiring authority has continued to engage with mana whenua over its needs and meeting its needs via the consent conditions, and it has achieved that through the most recent engagement of last week, where we finalised the relevant cultural conditions. And that is now reflected in the final set of requiring authority conditions that you would have received last week. That set of cultural conditions, the requiring authority says, as I say, meets the expectations and requirements of mana whenua, and we will hear from a representative from the mana whenua group later on this morning to advise of their views. But our hope is that we've found a way to ensure that the cultural issues associated with development of this nature can be addressed. And to your point earlier, being satisfied that Te Ture Whaimana is being appropriately addressed through cultural conditions. Again, we would say that is absolutely at the centre of all cultural considerations concerning development within the catchment of the Waikato River. So probably the only issue that feels like it might need some more discussion or teasing out is whether there's a need to go into more express detail about that in the conditions. The draft from the 42A author had been quite express in terms of breaking down some of those, particularly some of those other objectives within Te Ture Whaimana. And the question is whether or not dealing with this in a kind of specific way or at a broader way, and then relying on the partnership that exists between the RA and mana whenua is the more appropriate. And again, that might be something that you want to explore with the relevant witnesses.
Mindful also that, of course, there are regional consents down the tracks that will be required, and that we'll look at those issues as well. So.
Yes, absolutely. So remains a live and ongoing issue, as it should. Finally, in the submissions, there's just some response to the 42A addendum report, and I think largely these can be taken as read. I think the important point is that the 42A addendum report had produced a separate set of conditions which included all of the cultural conditions that they had recommended. And that was, I think, largely in response to some placeholders that had been put in the original revised consent conditions or conditions from the requiring authority while we completed the mana whenua engagement. And I think the point is, now that the mana whenua engagement has been completed and the final conditions reflect that engagement, the requiring authority's view is that those observations and concerns raised in the addendum report are all addressed and should fall away. We, I think, as a requiring authority group, consider that the final set of conditions are appropriate and that the designation should be confirmed on that basis. We have a series of witnesses that we've identified at paragraph 169 of the submission, starting with Tony Denton, who's the project sponsor, and as I said, we'll take a short break after him to hear from Joe in terms of cultural matters, and then we'll get back into it with some roading and transport related evidence. And in your hands, Commissioners, as to how long you wish to spend with some of these witnesses. Some may be relatively quick, others a little bit longer. All of them have executive summaries in their evidence. The intention was that they would read their executive summaries and deal with any questions. There's a couple of supplementary statements, one from James Balbooth, which is tidying up an acoustic matter, uncontroversial, but that needs tidying up. There's some supplementary evidence from Mr. Hick in terms of those updated land requirement plans and designs, which he can talk you through. And then we've got supplementary evidence from Ms. Slatter just on confirming where we've got to on conditions. And that's the intended run sheet for the requiring authority.
Mr. Muldowney, thank you. Let's take a break until 11 o'clock. Right, yes, till 11 o'clock by that watch, and then we'll resume. Thank you.
Thank you, sir. The first witness for the RA is Tony James Denton, who is the Technical Director, Transport Planning, Strategy and Programming at Hamilton City Council within the Infrastructure and Asset Group. And he is what you might describe as the project sponsor. So he has prepared a statement of evidence dated the 27th of June. He intends to read from his executive summary and then provide a verbal update on a few matters and then any questions. So I'll hand over to Mr. Denton.
Thank you, Mr. Denton, and welcome. June seems like a long time ago, I imagine.
Yes, it's been a long process. All right, I'm just going to read my executive summary as requested. So, the Rotorua Strategic Infrastructure Notice Requirement enables a transport solution for growth in the northwest of Hamilton, which is integrated with land use and supports key strategic planning documents, including the Rotorua Structure Plan. This transport solution will create substantial positive effects, including providing certainty for the future development of Rotorua, enabling the development of Rotorua, which will enable economic activity, including the provision of housing and employment, enabling integrated planning to occur, which will help ensure that the strategic transport and infrastructure networks will contribute to delivery of a quality, connected, urban and natural environment, enabling the reduction of private car use and greenhouse gas emissions, including supporting mode shift through enhancing active travel modes in public transport, enabling and supporting pedestrian and cycling movement, which will support and improve health and wellbeing outcomes, improving safety through the upgrading existing intersections and the Te Kowhai rail crossing facilities, visual, landscape and ecological enhancement through implementation of landscape and ecological management plans, and incorporating of cultural values into the design and delivery of the project. The staging and timing for the delivery of the infrastructure is subject to several factors, including funding and growth demands. Whilst there is limited funding for the delivery of the project in Hamilton City Council's current 2024-2034 long-term plan, securing a designation for the project will provide greater certainty for future funding processes and decisions. Further to my executive summary, without disclosing confidential arrangements, the RA team has had several engagements with the affected parties and submitters to listen and engage on issues of concern, some of which have been resolved in explaining and helping to understand the purpose and outcomes of the designation provisions, some of which the designation components have changed to support an agreed outcome common, some of which has led to introducing supportive notice requirement conditions. Lastly, some have led to HCC, Hamilton City Council, entering land purchase arrangements that have settled issues and problems, however, remain integral to the support of the designation. I would note that the HCC RA team has been open to engagement with property owners and the development community, actively working together where it has been seen as beneficial to facilitate and enable growth of Rotorua, particularly where it's supported by the Rotorua Strategic Infrastructure Corridor. Some of these engagements have informed existing development arrangements. As an update to the engagements, particularly with Submitter 6, Te Rapa Gateway, HCC has an agreement in principle with the Te Rapa Gateway to acquire its land directly affected by the notice of requirement, and we are in the final stages of concluding this agreement. The agreement includes the term to withdraw their submissions. That's me. I'm open to any questions.
Thank you. Just on that last point, so are they withdrawing their submission or simply not pursuing it?
At this stage, they've asked me to read that statement out to say they propose to withdraw their submission.
Okay, all right. Well, if they're going to withdraw it, we'll need some formal advice about that before we enter into deliberations, I think.
I think the state of affairs as we sit here this morning is that the submission remains live.
Yeah.
But as to...
I'd rather not have to write a paragraph or two about things I don't need to write a paragraph, that's all.
Yes, sir. So we will endeavour to close out the agreement and the legal position before you need to.
Appreciate that. Yeah. Okay. Mark, anything you want to... Maybe whilst you're just thinking, just a question from me. I mean, para 14, you've indicated that there's limited funding for delivery in the current LTP. I'm assuming that post the elections there will be a new round of LTPs next year. Given I guess the stage at which this NOR is, you envisaging or are you already working on submissions to the next LTP to bring that 9-year period down?
Hamilton City Council is already actively looking at its next LTP period components, and all I can say at this stage is the Rotorua corridor and infrastructure provisions will be
part of the mix.
Hope is part of that issue.
Okay, all right, that's what I would assume, so that's fine. So we're not sitting here thinking that nothing is going to happen in terms of LTPs for the next 9 years. So.
Correct.
Yeah, okay. Right.
Mr. Denton, you've seen quite a few major designations and projects around this locality over your career, and I'm really interested in your advice on the type of time horizon we're looking at. So we know that an extended lapse period of 15 years been sought. That's not something that's been contested. But we also know that this sits within a wider growth framework for Hamilton and its immediate surrounds. And so I'm really just after a little bit of commentary from you on how this sits within that and the types of timeframes that you've seen this scale of growth cell develop over. And I know it's, I'm not asking you to, not going to pin anything to it, but I'm just trying to, I guess, take some advice on around that horizon question.
When we did the Peacock's designation related stuff for Southern Links, I think at that stage everybody recognised it was a constrained funding environment to a certain extent, but equally the scale and size of delivering that particular project down there was going to take quite some time to actually formally implement everything as such. And so using the Rotorua example here, we did a close analysis, I suppose, in that space just to see could we have gone any faster or done anything different associated with this difference in approach. And I would argue that I'd rather have a longer time period if I could get it, but 15 seemed to be an appropriate time period to fit that scale of development in place. Does that answer your question?
No, thank you, Mr. Denton. If that's all you've got to tell us, that's fine. You're relieved, right? Yes. Ms. Kukatai.
Yes, so we're going to interpolate Ms. Kukatai, so go over to you. The floor's yours.
Just talk? Yeah. Oh, kia ora. The statement of evidence is submitted on behalf of mana whenua, Ngāti Mahanga, Ngāti Tamunipo, Ngāti Wairere, Ngāti Koroki Kahukura, Ngāti Haua, and Waikato Tainui engaged in the Roto-Kauri Strategic Infrastructure Corridor Project. I just want to acknowledge our mana whenua that are here today. My name is Jo Kukitai. I'm the chair of Ngā Reo Mahanga Trust Board, and within mana whenua, I represent Ngāti Mahanga. Hold a Diploma in Business Computing, Bachelor of Information Technology, Bachelor of Laws, Master of Social Science Geography, and I'm currently completing a Doctorate of Philosophy and Environmental Studies.
You're not sure what you want to be, is that what you're telling us?
Yeah, something like that. And I'm an accredited RMA Commissioner. And today's my first hearing. I'm here today representing our mana whenua collective of Ngāti Mahanga, Ngāti Tamunipo, Ngāti Wairere, Ngāti Koroki Kahukura, Ngāti Haua and Waikato Tainui for the proposed designation conditions. In terms of mana whenua engagement with the requiring authority in the proposed designation conditions, mana whenua has engaged with the requiring authority on the 27th of August, the 10th, the 22nd and the 25th of September, and because of that engagement, endorsed the proposed conditions. Matters of significance, mana whenua is currently implementing works for the Roto-Kauri Greenway project, and we see that the approval of these proposed designation conditions in their current form would further support our mana whenua aspirations in the overall Roto-Kauri project. Mana whenua is confident that these proposed conditions from the requiring authority upholds Te Ture Whai Manawa Te Awa Waikato and supports other existing Waikato River arrangements. To conclude, mana whenua comprising of Ngāti Mahanga, Ngāti Tamunipo, Ngāti Wairere, Ngāti Koroki Kahukura, Ngāti Haua and Waikato Tainui support and endorse the proposed designation conditions from the requiring authority as attached to the Memorandum of Council on behalf of the RA dated 30th of September 2025.
Thank you, Ms Kukitai. And you can confirm, can you, there are no other mana whenua who would otherwise stand in this particular place on this?
No.
You cover the range?
Yes.
Yep, okay. Mark? That's very helpful. Thank you very much.
Thank you.
So back to the requiring authority sequence of witnesses. The next witness I intend to call is Mr Hick, who is going to give evidence in relation to the land requirements and some of the transport engineering matters. So over to you, Mr Hick. You have, I think, produced a statement of evidence dated the 27th of June. And you're going to read from your executive summary, and you've also got a supplementary statement, is that right?
I do.
Yep. Over to you then.
So, executive summary from my primary evidence. If I start at paragraph 9, my evidence provides a summary of the general road design parameters adopted. It discusses alignment selection to the north of the minor arterial, bridge clearance constraints and possible mitigation options, and the brownfields section access philosophy. My evidence discusses the following submissions. Submission 2, take that as read. My evidence discusses section 42A report and technical specialist report issues, acknowledgement of cross-section consistencies and confirmation of proposed widths, discussion around cross-section for minor arterial carriageways and interface with emergency services, access to the property 40 Te Kowhai Road East, and geotechnical conditions relating to future design stages. In conclusion, I've got recommendations for the following. Consideration be given to cross-section requirements after discussion with emergency services. During subsequent refinement, the consistency of road cross-section environment is considered to help reduce driver frustration and or confusion. As HCC confirms flood levels in the Greenway, determine the clearance available under Te Kowhai Road East underpass. And then I've said that if a clearance of less than 4.9 metres is adopted, liaise with NZTA to discuss whether further mitigation is required. D is confirm at detailed design appropriate barrier system and design arrangement to protect existing bridge piers at State Highway 1C underpasses. Consideration is given to appropriate crossing points at any additional path termination treatments for the SH1C river cycle path across to Kowhai Road. And at the time of detailed design of the arterial corridor, consider adjacent development plans and consented layouts to determine whether any amendments to the design can be mutually beneficial. And the last point is geotechnical design considerations are assessed at the next design stage, pending an appropriate level of investigation is undertaken. So that's my primary evidence. Shall I roll into supplementary statement or? Sure. So, the scope of my supplementary evidence is provided on behalf of Hamilton City Council as the RA, is to provide updated technical documents in accordance with agreements reached following lodgement of my primary evidence or in response to the S42A reports. So if I jump to paragraph 6, I've just skipped the exec summary. What I'm doing here is, as part of Ms Slatter's rebuttal evidence, we have updated the land requirement plans to be in line with the HHL request, which is to alter it for wetlands 4A, 4B, 6 and 7A. Point 7, I just note what those drawings are in those revisions. So in point 7, those are land requirement plans. At point 8, what we've done is also updated plans which are in the same physical location as the updates to point 7. So it's just really 8 and 9 really are for consistency, so the designation boundary will appear the same on all plans. And I just note what those drawings and revisions are under points 9, 10 and 11. Updates to cross sections. So in point 12, I just refer to my primary evidence, which it was pointed out by the 42A review that there were some inconsistencies in terms of widths shown between appendices and also just in terms of some maths. So I've repeated the table out of my primary evidence, and I will introduce the updated cross sections. In point 14, I just note that the requirements from HHL's fast track resource consent application can be adopted within the footprint that we're proposing. So under 15 is the drawings and revisions for the cross sections, and then 16 I'm attaching a diagram showing indicative connections between the pedestrian cyclist facilities, between the RSI transport corridors and the facilities within the RSI Greenway designation. And this is referred to in Mr. Richard's primary evidence, and we're just giving that a formal number now. And it is attached in the road and drawing set, I believe. 17 is just my support for Ms Slatter's final set of designation conditions, and they've been provided and I've reviewed and support them. And then I just have conclusions. Do we need to read the conclusions? It's basically the same. Sure.
So could I just lead this witness through a couple of final points? Mr. Hick, up on the screen there was an image that we talked about in my opening legal submissions, and this is a document showing the comparison between the land requirement plan that was originally part of the NOR versus what we are now promoting as the land requirement based on your updated drawings. And I just wonder if you could just zone in on that area there. That's really the critical part of the change, isn't it? Which is in blue outline the original NOR land requirement, and then orange dotted outline is the new drawing. Is that right?
There are two locations. So where you've noted there in the middle of the screen, there's also a minor change at the bottom, sort of middle right of the screen too.
Yes.
Yes. So those are the two locations which are amended.
So blue dotted line original, orange dotted line updated.
Correct.
Now that comparison drawing is not currently part of the formal record, and if I could just introduce that as an exhibit of some sort of, however formal you want to be, but that needs to become part of the formal record, sir. Thank you. And then just in addition,
confirm that. So the expanded area, is that the consented area or is that the designation, greenway designation area?
it's the consented area, isn't it? Yeah.
It's the consented area. Yep. Okay, all right. And so presumably the designation area is wider than that again, one would assume. Can that be confirmed?
Can we take that one offline? I want to come back on that point.
Absolutely.
Do you want to deal with that now, or what's the best way to deal with that? Are you across that?
If at some point you just confirm.
I think we're going to need to come back on that, if we may.
Just want to be absolutely clear, just in terms of those overlap issues with the designations as to where it is. So it'd be useful just to have a maybe just a plot that shows the difference, if there is a difference.
All right, well, we'll come back on that one and tidy that point up. Just the other point I just wanted to make is if we just scroll across to the Te Rapa Gateway site, just there, perfect. Now, included, see that wedge where the cursor is, there's a blue cutout there. Now, Mr. Hick, as I understand it, in your updated drawings, that blue cutout is not actually reflected yet, is it?
Correct. So the areas
Yep.
are the same between revisions, but the hatch there, that grey hatch, shouldn't be on this plan. So the little cutout remains Te Rapa Gateway.
So this is a point which I just want to clarify. So under the negotiations that are ongoing with Te Rapa Gateway and that settlement, that internal piece, the blue dotted line piece of that, which sits inside the footprint of the designation, is actually going to be, it's not going to form part of the land requirement plan. It's going to be retained by Te Rapa Gateway. So it's not going to have the designation across it. And so Mr. Hicks's updated drawings and his evidence needs another update to reflect that piece of the negotiation, which has just recently come to light. It won't be road. It will be a developable piece of land that somehow there'll be some kind of access way, and will be something that accommodates an industrial use. But you can see there, in terms of the nature of the corridors that are intended, it does look like an unnecessary sterilisation of land for designation purposes, and I think that's probably the point. I think they've said let's rationalise this sort of big wedge out into something. Let's figure out what you need and what you don't need, and what you don't need will be developed for industrial purposes. So I think that's what's going on. So we'll just update the drawing to reflect that piece. All right.
Thank you.
So just remain there and answer any questions.
Sure.
Just thinking about that, how do you fit? I mean, do you have to GPS that piece out, or I mean, how does that work in terms of the practicalities of physically drawing the designation boundary? Because it's just a lozenge at the moment, but that's not adequate, obviously, in terms of its, I mean, well, maybe it has its own title, so it might be quite simple, I don't know. I'm just curious as to how mechanically one would do that. I mean, you can't just put your thumb in the design and say, well, there it is.
No, you can't.
Yes,
Yeah.
yeah.
So just to give some direction, I suppose, that the land purchase agreement that we've entered into there is to purchase everything except for that.
So you'll survey the boundary or
that
something
shape.
and
So it will
exclude it.
have, and it has a clause in there in terms of us having to do the final survey and
Yeah.
detail of that to separate those into
Yeah, okay.
separate lots.
All right, that makes sense. Thank you.
So as long as we get the designation land requirement footprint right,
Yes,
the rest of it can kind of fall into place.
yeah, yeah.
So we will make sure that what we do produce for you overnight, when we reflect this, will be an accurate account of the land requirement for the designation.
Okay, that's good, yeah. Just so long as Mark and I don't have to sort of, draw lines around things and say, not for, yes, right.
Thank you, Mr. Higg. Just a couple of little questions from me. One relates to some discussion in your evidence around paragraph 82, your primary evidence, which discusses the road cross sections and the extent to which they need to or need not accommodate emergency service vehicles. And I'm interested in this because, again, it appears a point where there's not total alignment between the two parts. So I'm curious about some commentary in there that the cross-section may be adjusted to provide additional space to emergency vehicles, but that there will still be cases where they might not be able to pass. And so I'm just interested in getting some surety that the designation footprints are sufficient to provide the flexibility required for those next stages of detailed design under the proposed solution and conditions, which I know differ on this point in relation to best practicable access versus some other version of wording that doesn't quite get to the same point. But I'm just wondering, could you expand on that a little bit for us, please?
Yeah, so I think it was raised in the 42A report that the amount of road cross-section available was essentially a traffic lane width. And we had a raised median in the mid-block, and we had substantive amounts of berms and paths to the sides. So this is really applicable to the minor arterial. The major arterials, the 4 lanes and stuff, is a moot point. So we're talking about really mid-block sections. And so we talked about this as a team, and I think in my evidence I agreed with the comment that it might be difficult in 3.5 metres if you had a broken down vehicle, or if someone pulled to the side, some things might get through, some things might not. So what the approach that I've taken is that we have something like 30 metres of carriageway, or of formation from sort of the back of the berm to the back of the berm. And so there's a number of ways that I guess the whole thing relies on further discussion at later stages with RFNs. So we haven't had that opportunity yet. And so once we can understand what their drivers are, the amendments that we're suggesting are possible can be made or could be made if necessary. So, for example, I guess the fire people might say, well, we'll just drive up the other carriageway, or they might say, no, we want a little bit more space. So after that's happened, the theory was that the 3 metre median could be reinforced in some way so that some people can drive up the curbs if you didn't want to, you know, reduce the width. You could reduce the width slightly of the median, add more shoulder, marginally more shoulder. You could add more left-hand shoulder, reduce the berm slightly, reduce the back berm slightly, reduce the paths. There's also substantial path width available too. So the feeling was that within that space, whatever happens out of those future discussions, minor tweaks can be made to that. I guess the other thing is also, at the moment, we're showing some nominal earthworks batters outside our footprint or our formation, and so that would either go up or down to the natural ground. And it's currently included in the designation, and then that rollback will come in. And so there is potential to also utilise a little bit of that space if necessary, outside that 30 metres. So cool. That's the thinking.
Thank you.
Sorry, just to pick up on that point, just so that everyone's clear. So the current final set of conditions promoted by the requiring authority does have a condition dealing with this emergency access, and it talks about the provision being of reasonable access. I think the issue between that and the 42A team at the moment is that they're requiring best best practicable, and so the concern from the requiring authority's perspective as well. How do we measure that? What does that mean in when it comes to time costs and the expense associated with delivering on best practical as opposed to reasonable access, which clearly carries with it an input that it's passable. I think if you're looking for, well, how do I define best practicable or reasonable? Reasonable in this context must mean passable, and that surely is what the condition should be directed at. Safe, passable. So, I mean, if you're looking for different words, there's a couple: safe and passable. If you're looking for better certainty than reasonable or practicable.
We'll leave the thesaurus to you.
As I say, just on this issue, that seems to be what it's come down to. So it may be that we can figure out a way through that pretty quickly.
We'll get an understanding of what's intended by Mr. Ryan, also in terms of his use of words, because they may be the same thing, because you can read best practicable to mean the same thing, obviously, if you go there.
It may be that both could be improved by safe and passable.
Yes, right. Okay. Well, if that's all we have to do today to sort that word out, I'll be more than happy. I was just going to ask you, Mr. Hick, somewhere in this massive paper there are landscape and cross-sectional diagrams for each of the minors and majors and so on and so forth. If you're now saying that in actual fact there are going to be some overs and unders in terms of satisfying fens, then those diagrams that are part of the application, and I think they're intended to be attached to the conditions, will need to be adjusted, won't they? I mean, if you're going to take some of the berm away, whether it's front berm or back berm, or whether you're going to take the footpaths or narrow them, then and I can't recall, Mr. Adam, maybe you can help me on that one. Are those titled indicative, or are those titled they are the cross sections? Because I've got a feeling they're actually put down as the cross sections.
They are the cross sections. However, the condition reads that they are generally in accordance. So there's an element of movement there as that concept design gets refined.
Yes, that dreadful term again. Okay, yes, all right. Okay, well, if they're generally in accordance, then you've got that flexibility, obviously, so that covers that point off. Thank you. Yeah, I had the same paragraph 82 that I wanted to get in, so thank you for that, Mark. No, just confirming, in your paragraph 75, you've recommended following widths adopted. Have those actually been adopted? Just want to be clear that...
They have been adopted, yes, and I'd just make the point that they're mainly in regards to consistency between the ULDF and the cross sections, or just minor typos in some of the text.
Right. And so when you say they're adopted, is there agreement with council on those matters, or is that still in dispute?
I don't believe it's in dispute. They're in,
Can I just quickly check that with you, Mr. Ryan? Are those, looking at his paragraph 75, are those widths now agreed with council, or has council got an issue with those?
Alan Gregory will be able to confirm that tomorrow, but I think we're right with those.
Okay. I mean, it would be helpful. Oh, no, I won't go there. All right. Let me just check. Oh, yes, I just want, can I take you to the your response to submit a section, paras 42 following, which is the Mr. Jameson's submission on behalf of whoever, Sapphire, isn't it? Just talk through the sort of discussions that you've had with Sapphire on the, the alternate routing of trucks and so on from the site to the proposed cul-de-sac.
So
has that been a desktop exercise, or is that?
I haven't personally met, but we have been as a team. And
oh, Mr. Denton, he's wanting to jump in, right?
I was going to suggest help him. I'd probably entertain most of
well,
it
doesn't sound like help. It sounds like you're taking over. That's fine. Yes. Yes.
I can just, well, if you wanted me just to talk to 42 and 43, it's really about the new proposed access being off the cul-de-sac and access into the property.
Yeah.
And that's as far as that went. There's been subsequent conversations, I understand.
Yep.
Oh, well, I didn't even see your lips move, Mr. Denton. That's pretty amazing. Yes, well done. Yes. Yeah. Okay. Go. Yeah.
And this is just one final thing, and it relates to the point that you raised earlier, Mr. Muldowney, in relation to the kind of natural justice questions here around shifting designation footprints. Now, I'm taking it that there are no newly affected landowners that aren't either part of either of the previous designation, the current process, or the fast-track consent that are affected by the change in footprints.
Not that aren't already submitters in the process.
No.
I understand it.
Thank you.
Correct.
If I just turn to your paragraph 87, you have a proviso in the middle of that paragraph, and again, I just want to check whether that proviso is, it's still a proviso, or that's been able to be confirmed. You said provided adequate pavement drainage, subsurface drainage, stormwater drainage, and so on can be provided. A change in the elevation of the vertical alignment is not expected to change transportation outcomes sought. Just explain the why that proviso is not certain.
I think this is referring to the fact that the vertical alignment that council were proposing to the south is actually lower than ours, and so I'm just responding to that to say that we have no issue as long as all the other engineering things that go along with it, make sure that a subsoil drains can exit and we can get cover for culverts, etc. As long as that's able to be maintained, then we have no concern.
So that's a paragraph that we might expect a response from council on tomorrow, Mr. Ryan, is it? Is paragraph 87, is that a proviso that we might expect a response from council on to confirm that it is practicable or in hand, or that you accept the argument?
I don't think we currently have in what we're proposing to table tomorrow a comment on that, but we can clarify that for you.
Well, as I'm intuiting from what Mr. Hicks said, it's his response to a proposal from council. So,
sorry, it was council
from HHL.
Sorry. HHL. Yes.
From HHL.
Sorry. So the first part is talking about the HHL alignment. The second part from Mr. Bresky is the recommendation about some settlement monitoring, which we do have in our current proposed condition set.
So if that's HHL's, if that's in their bailiwick to resolve, how do we get certainty on that?
Well, that'll be up to HHL at the time, I guess, to do, you know, when their road is approved, that they will have to work through those things, is really what I'm saying.
How does that happen? If they say, no, we're not going to do that.
Well, they'll be subject to the requirements of well, obviously the designation, but also the regional technical requirements. So the RITs, for example, will specify a whole lot of things around that, and they will be still bound by those as well, would be my expectation.
I mean, I'm just concerned about the latter part of that sentence. He says, not expected to change the transportation outcomes sought, but I'm just trying to understand what that actually means. Because it suggests that it might not be done. That's what that suggests.
I think it's just an interpretation piece, David. It's, there is intent to build what they are planning to build out there. They've got consents and it's currently going through engineering approval related stuff, matching very closely to what our designation provisions are trying to achieve.
Right, right.
So I can give you some confidence that there shouldn't be a problem in that space.
So that will be resolved through the engineering approval step?
Yes.
Yeah, okay.
There would also be, again, the 176 approval process with the overlapping of the designation. So if there's an outcome here which proves unacceptable to Mr. Denton as RA, he'll have the opportunity to deal with that through 176. So it should have the protections that you need to ensure you don't get the outcome
Right.
which is
Okay.
signalled here as the concern.
Okay, all right. It's a triple proviso, and I don't like triple provisos because the more provisos you have, the more likely it is that actually it's not going to happen. So, yeah, all right.
Sorry for bouncing around a little bit here, Mr. Hick, but just one other question, and it's one of these subtle things. We talked about the things to be in general accordance with the roading cross sections. Totally understand that. Another area where again there's a little bit of space between the two parties was in respect of the RITs, the infrastructure technical specifications and the conditions, and one version of conditions from the council which sought works to be in accordance with the RITs, and the version of conditions that comes from the RA is that they should be in general accordance with the RITs. Could you perhaps tell me about why that flexibility is necessary?
Why that flexibility is necessary? I guess particularly with well, the RITs is written in a specific way, and most of the time it's fine, but I think on a job of this scale with a whole lot of competing demands and everything together, you know, going along the greenway, clearances under the bridges and things like that, the RITs might specify something like your clearance shall be X. And so what we want to do is make sure that, yep, we're pretty sure we can do that, but through the development, we want to make sure that if it's a minor discrepancy or a minor relaxation, if you like, from the RITs, then that's actually not going to cause a massive issue. That's one of the things I can think of. I'm trying to think if there's anything else, but that's the kind of the rationale.
Okay. Thank you.
All right. Thank you, Mr. Hick.
Thank you.
Mr. Richards.
Morning.
Mr. Richards, you've produced a statement of evidence dated the 27th of June. you have that in front of you?
Yes.
And within that is an executive summary. I'll just ask you to read that, please, and answer any questions.
Yes, no problem. Commissioners, we prefer I read the executive summary in full or summarise? I can summarise the summary if you prefer. So my name is Craig Murray Richards. I prepared the ITA for the NOR, which assessed the effects of the proposal on the transport environment. The ITA evaluated the transportation effects of the designation and informed the designation conditions to best ensure that any adverse transport effects are avoided, remedied or mitigated. The ITA concluded that the designation design accommodates a range of travel modes, traffic, buses and active modes to provide travel choice for future residents and visitors. The road and intersection designs and cross-sections can accommodate the expected future travel demands, and the proposed designated transport network is broadly consistent with national and regional transport policies and objectives. There's a section in my executive summary around the Waikato Regional Traffic Model volumes, which we initially obtained in preparing the ITA, and we applied a 30% uplift to those initial volumes on a basis of some uncertainty around those volumes. Since the ITA was developed and more recently the WRTM, or Waikato Regional Traffic Model, has been updated, and we received new updated volumes from December 2024, and then we re-evaluated the traffic modelling with those updated volumes, and those the results of that are described in my primary evidence. I'll take as read my evidence discusses the submissions as noted there and the relevant matters in the 42A report. In conclusion, my conclusions that the updated transport modelling demonstrates the road network is predicted to satisfactorily accommodate the traffic demands, and the designation design can safely accommodate a range of travel modes, as I've said. Just to note that the preparation of the implementation of the construction traffic management plan as per the conditions will appropriately address the transport effects. I have a minor correction to make to my primary evidence, just in relation to figures 1 and 2 in my primary evidence. This display transport model volumes taken from the Waikato Regional Transport Model. Those figures display where it's displayed as previous WRTM volumes plus 30% uplift. I've ascertained that the figures shown actually show intersection volumes and not corridor volumes, so they're not directly comparable to the volumes, which are the future volumes that I've displayed in that figure. Figure 1 and 2 were provided for context to show estimated future traffic volumes. Yes, yeah, effectively both figures, they're the same, but figure 2 takes figure 1 and adds the future volumes, if you like. So
Was that also an intersection volume, or was that a corridor volume added to the intersection volume?
No, sorry. So say figure 2, just the black boxes, previous WRTM volumes, the intersection volumes. Yeah. The updated WRTM volumes are the recent volumes that we got out of the WRTM. So they're correct, the recent volumes. Okay. It's only the black ones, which had actually superseded.
Well, the black boxes are irrelevant.
Exactly. Yeah. Yep. So you've summed my point up quite nicely there.
Okay. So just to clarify, the updated figures are included in the supplementary bundle of evidence at tabs 2B, and we have the revised figures up on the screen if you need them, but we'll just scroll to amended figure 1 first, please. So that changes those numbers in each of those boxes, and then also the figure 2, there's a change to the numbers. So those are the updated figures, and they're at 2B of the supplementary bundle, and those would replace figures 1 and 2 in his statement of evidence.
And just confirm that the model actually assumes the existence of the designation, or the builder, I should say, of the designation.
Yes, that's correct. Yeah, if you go to 2051 future network and land use in the area. Yes. Yep. Oh, that's it from me, yes, thanks.
Thanks, Mr. Richards. Just zooming in for a moment on the area around the level crossing. I think, you know, it's not a perfect scenario, and I don't think anyone's saying that it is. But what I'm really interested in is a little bit more. I think you get into it, and the thing that triggered me was, and I accept some of the figures have changed subsequently, but at paragraph 23 you talk about potential tailbacks at intersections. And some of those numbers started to make me think, how are these tailbacks going to be managed in relation to their proximity to the level crossing in particular? And I'm really interested in how that interaction between the signalised crossing on one end, the next signalised crossing immediately adjacent to the level crossing, and then the, I can't remember quite what the intersection treatment is.
Roundabout, yes. Yeah.
But that sequence with the middle crossing in the middle, I'm really interested in kind of understanding, once built out, when, notwithstanding some changes in the figures because of the updated Wharton model, really want to make sure that we're setting that up to function efficiently.
Yeah, that's a good question, and something we'd looked into quite closely with the traffic modelling, because we're obviously also concerned about that spillback, particularly across the level crossing, and that's something that Kiwi Rail have been concerned about as well. So, yeah, the traffic modelling and updated traffic modelling for 2051 does indicate that those queues will be less than or shorter, contained within that space. There's also provisions there around, obviously, with traffic signals, you've got a bit more ability to monitor queues, so have, say, queue detectors on the approach linked to the traffic signals. In a case where the queue gets reaches that detector, then the signals would provide more green time to make sure that doesn't spill back. And I think there's also provision in the design for space near the crossing for vehicles to pull over to escape, a little escape area if they do cross over and then the queue's back, then there's some width beside the road for vehicles to escape off the road. All those things have sort of been taken into account in the design to provide a safe environment there and avoid that issue of spillback. Yeah.
A little further to that is, we know in the slightly wider environment there is a major transport hub located on Tasman Road, with the rail station, yes, and inline bus stops, etc., which will presently be turning right at that junction, and again anticipating a future traffic environment that's significantly more, got a lot more going on. How will that be facilitated?
So that's a signalised right turn at that intersection. You mean the Tasman Te Kaupawai East intersection?
Yeah, that's right.
Yeah. So the traffic signals will facilitate the right turn out of Tasman Road. Yeah.
Can I just on that point, Tony? Do you want to just talk about the sequencing and the way that the signalisation works, because it's all integrated, of course.
Probably some background. On the current situation, you can see there's two roundabouts that sit either side of it, and in the early investigations with just the general operation of those, you can see at certain times there is extents where traffic does get very close to the rail crossing, and so we decided early on to figure out ways of mitigating that and removing those issues, and the signals for all three intersections are really important to be able to, and its correlation with the signals for the rail operation as well. That as a train is coming, we can do something that actually frees up those intersections and removes that congestion of traffic if it's existing, and let the train run through freely without any issues in that space. So there is a collaboration with ourselves and Kiwi Rail to make sure that that function works well. The same thing with the Tasman Road and the rail hub location and bus network relationship is the signals need to be set up in a way that allows buses to potentially jump ahead of other traffic as well in those situations at certain times also in peak periods. But it's all about trying to use the signals as best as possible to manage the safety risk in that location.
So can I check? So does that harmonisation occur now, or is this a future prospect?
It's all part of a future prospect. There is no signal arrangements in that location other than the...
I mean, it seems an obvious
standard.
thing to do, but obvious doesn't always happen, does it?
Yep. It doesn't exist at the moment.
Yeah, okay. All right, but it is intended?
It's intended, yes.
By both parties?
Yes.
Okay.
Thank you.
Thanks, sir. In keeping with this theme, I call Mr. McQueen to give evidence in relation to the level crossing. Mr. McQueen, you've produced a statement of evidence dated the 27th of June 2025.
Correct.
You have that in front of you?
I do.
Could you just read from your executive summary, and then if you have any other comments that you want to make, please make those and then answer questions.
Okay, reading from paragraph 8. In my opinion, the risk assessment and management process set out in the level crossing risk assessment guidance has been applied appropriately, and the conclusions agreed to by Hamilton City Council and Kiwi Rail are appropriate for the Te Kowhai East Road level crossing as affected by the project. The conclusions of the so far as is reasonably practicable review with a grade separation and closure were not reasonably practicable. Closure was found to be a suitable and available option, but the cost was grossly disproportionate to the safety benefit. Grade separation was found to be a suitable and available option, but the cost was grossly disproportionate to the safety benefit. And with regard to the conditions, in my opinion, the proposed designation condition, which is advisory note to condition 4, is appropriate for the Te Kowhai East Road level crossing as affected by the project. I don't have any further comments at this stage.
I mean, I understand that these terms are drive out of the legislation, and that's the basis for making a finding of disproportionateness. In your evidence, you indicate that in actual fact, the cost of grade separation, for example, are well, to use the term, grossly disproportionate. What scale of costs are we talking about?
There was reports I received into the cost of grade separation, which put the cost, I believe, at $110 million or thereabouts. I don't recall the precise number.
Right. And I'm just
yeah, I beg your pardon, the numbers are in the evidence at clause 28.
28? Yep, okay. 20. Yes.
It was 106 million for grade separation
and
113 for closure.
For that. Yeah, right. Yeah. And I mean, yeah, it is what it is at that point. But just comparatively, I mean, on an international standard scale, is this comparable? Are we talking the same sort of risk profiles, or we have a, I guess because of the state of the infrastructure, we have a higher tolerance of risk here?
Yeah, I can't really comment on international comparisons, but within New Zealand, this is a
well, it's yeah. I mean, it's a national platform, so I understand that. Yeah. All right.
yeah.
won't take that any further. Go for it.
Thanks, Mr. McQueen. Are there any other locations in New Zealand that you're aware of where, to facilitate growth of this scale, an existing two-lane level crossing has been increased to a 4-lane level crossing?
I can't bring to mind that specific circumstance off the top of my head, but I'm aware there's a number of other large projects around the country, Auckland, Wellington in particular, Christchurch, Rolleston, where there are significant transport projects which impact level crossings, and the same process has been adopted there and come to its conclusions depending on the circumstances.
Right.
So this is not a left field or completely outlier type of circumstance. It does happen around New Zealand, yes.
Thank you. And the other thing, and it comes from, I guess that's why you're the expert. I'm really just curious a little bit further in, that the implied cost of avoided fatality metric, and it's really just a matter of kind of ensuring that the planning work that's done has adopted common assumptions throughout, and including in this. So I'm interested in what the kind of planning horizon is that's been applied in this work. So is it at full build out of the growth cell that's being serviced by the designation, for example, or something else?
Yes, the process looks at when the project opens, so to speak, and also a 10-year future horizon. So in this particular case, we've used 2032 as the start point and 2042 as the future horizon. So that's the consideration of future developments. Okay. And that's informed by material we received from Hamilton City as to how that should be done.
Okay. Thank you.
Just characterise, if you will, how the safety benefit is determined, just broadly.
Yeah, the risk assessment process includes a assessment model which is used widely in Australia and New Zealand that has an output or a range of outputs, but one of them is a modelled return period between fatalities at the crossing. And that information combined with the published...
And that's based on what? How does that figure pop out of whatever it is that you're using?
The model, which is the OOctober model, the Australasian Level Crossing Assessment Model, takes data specific to the crossing, like view distances, volumes of traffic.
So it's specific. So this intersection or this cross connection has been modelled. There's data about incidents and so on.
Yes,
yeah.
Correct.
Okay.
Correct. And the other part of the picture is the value of statistical life, which is published here in New Zealand by NZTA. Last published was $12.5 million. And those two pieces of information are put into a simple piece of arithmetic to come up with the ICAF ratio. So there's the cost on one hand and the value on the other.
So tell me, how does the model look in this instance to the future, with a fairly significant uplift both in the development in the area, but also in terms of traffic density and so on? How does it work that through?
Yeah, the model,
I mean, how predictive is it, I guess, is really the question.
The model runs scenarios for the opening state, as I mentioned before, and for the future state, and produces those same range of outputs for each one. And in this particular case, if we were considering, say, grade separation, then the assumption would be that grade separation would eliminate the risk which the model has determined, and that is used to calculate the value of the safety benefit and compared to the cost of building the grade separation.
Right, okay. So, I mean, in your paragraph 29, you've given some numbers here where you said the ICAF exceeds 10. That's the threshold for moving towards grade separation, presumably. What's a 36? Just tell me what that means. You've said for closure of Te Kauwhai East Road, that 36, what does that actually mean?
ICAF, which is the ratio of cost to safety benefit. To step back a little bit from the question for a moment, if I could, but the guidance document provides a range, or provides guidance that if the ratio is 2 or less, then the cost will be considered proportionate. If it's greater than 10, it will be considered disproportionate, the way the Act uses those words.
Right.
And in between requires some further consideration. So when the number 36 comes up, that says the ratio determined for that particular case at Te Kaupau East Road is 36, comparing that to 10, it is well in excess of 10. So the
does the model help you does it tell you how that 36 might convert to 10? Does it sort of give you some sensitivity analysis in terms of what might need to change in order to bring that down?
It does. It's a simple ratio. So if
it is a straight ratio.
If the cost of the build was halved, then the number would come down.
Yeah.
Okay.
All right. So presumably it uses factors for the value of a lost life or something like that as part of the equation.
It uses that value of statistical life number.
Yeah. Yeah. Okay. All right. All right. Interesting. Not totally relevant, but interesting. Right. Anything more?
Yeah, perhaps maybe just for Mr. Denton, this is again just a time frame thing. I mean, I asked you a little bit about time frames earlier on, and I know it's, I know your crystal ball is probably the best polished crystal ball in the room. At 2042, does that correspond with the approximate understanding of build out for that gross cell?
Yes.
Thank you.
Yes. Yep. Got different model for different time periods. It is based on a whole lot of assumptions as well, but the assumption is that Rotokauri fully filled out in that location as part of this assessment.
Thank you.
So what's the difference between the numbers that we had shown up here for 2051 and 2042? Is there a significant difference in that? Is there growth in that 9-year period, for example?
So the 2042 number is very similar to the 2051 or 50 number that we currently have in the model. We had a model upgrade change, and we had different time periods. So when we first started this exercise out quite a few years ago, there was a 2041, 31, 21 time periods. They have now moved to a 35, 45, 55 time periods, but they are reflecting very similar, if not the same values in those periods. Correct.
Quinn?
Thank you. Sir, I call Mr. Balbooth on acoustic matters.
Right.
Oh. Sorry, I'm calling out of order, I'm told. I'm reading from the wrong thing, so...
Oh, gosh. Yes, you can...
So just pause.
Get your
I'll
heart
go back to the
under
script.
control. Yes, right.
I like to spice things up. We're going back to Mr. Smith on stormwater.
I'm wondering whether, in terms of timing, oh no, we might get Mr. Smith done in 20 minutes. We'll aim to do that. Yeah. Okay. Welcome, Mr. Smith.
Thank you.
Mr. Smith.
So I'll read from my executive summary. So the purpose of my evidence was to outline how the RSI design would allow for the stormwater effects from the proposed roads to be appropriately managed and provide for key stormwater management features needed for future subdivisions as well. But where these relate to the RSI roads, there is a distinction in there. The project includes stormwater features that are directly related to managing stormwater runoff from the roads, and that's that distinction, but also where those accommodate stormwater subdivision runoff at the same time. Yeah. So it allows for the key strategic stormwater features and corridors so HEC can secure the appropriate stormwater outcomes for the future. And these are formed from constructed wetlands for both water quality treatment and flow attenuation, which essentially is flood management. and also for corridors for new conveyance channels in the form of naturalised streams. Only the constructed wetlands that receive runoff from the RSI roads are included in the NOR. So this leaves other wetlands serving the remainder of adjacent subdivisions outside the proposed designations, and they're shown for developers really to design and implement as part of the wider subdivision. The RSI stormwater design is to a preliminary stage suitable for setting land required for the designation. As it is standard with infrastructure, further design and assessment will be needed to support future resource consent applications, an outline plan of works, and to produce documents suitable for construction. And these more detailed designs will need to be integrated with adjacent subdivisions, and will also, part of that will need further flood modelling. The RSI stormwater design is in accordance with the current ICMPs and the design used to support the Greenway designation. Therefore, the RSI design aligns with established and approved policies for managing stormwater in these catchments. It's these documents, along with other related technical design standards, that determine the sizes of these stormwater features. The ICMPs and the Greenway documents do specify flood storage volumes required for the RSI constructed wetlands, and these studies were based on modelling and included allowances for climate change.
They accord with current specs and requirements for that?
Yes. For water quality requirements, standard design guidelines for sizing constructed wetlands have been applied, and it's in combination of these with the flood storage requirements that determine a footprint for a constructed wetland. The locations of these constructed wetlands south of the Greenway and the terminology that we've used is G for Greenway, really G4A, G4B, G6, G7 and G8. In the council designs I've dropped the G, but the numbers are the same. These were discussed with related land developers at the time of the RSI design, and subsequent to this, HEC has entered into private developer agreements with Council Holdings Limited for the delivery of the southern part of the Greenway and also the related constructed wetlands. So the fast track consents have been granted for these, for the Greenway corridor and some of the wetlands associated and the associated earthworks. For detailed design, further detailed design for the Greenway and wetlands 4A and B has subsequently occurred, and this work included updated flood modelling integrated with the wider proposed subdivisions. So there are differences in the designs, location and footprint proposed by HHL. However, they achieve the overall outcome. They achieve the same, or if not better, overall outcome than the proposed RSI constructed wetlands. The submissions related to the stormwater matters have been responded to, and additional information is provided as part of the evidence. The Section 42A report raised several issues that have been responded to, and additional information again provided in the evidence. So in my opinion, the RSI design identifies sufficient land to deliver the stormwater infrastructure features. These were designed in accordance with the Rotorua and Mangahika ICMPs, and the NOR appropriately provides for stormwater management of effects arising from development of the RSI roads. There are still some issues that remain for future resource consents to address, and in my opinion it's the appropriate mechanism for doing so. So in my view, subject to the recommended designation conditions, stormwater effects are appropriately managed, and there are no stormwater matters that will preclude the confirmation of the NOR and designation, for the designation I should say.
Do you just want to run your supplementary as well? I think you have
I don't have a supplementary.
Oh, you don't have a supplementary. I thought you did. Okay, thank you. Just give us a bit of a teaser on 25. What are you thinking of that the issues that remain for regional council consents?
With the design of a subdivision, when you've got the wider earthworks, you'll need to retest or prove in flood models when you've got the wider subdivision design with as the roads progress. So there's a level of design for a designation that will carry on going until you get to a detailed design. So that would be one. And another one that springs to mind is dealing with regional council with the additional volume that's discharged by the roads, and that will require negotiation. That usually happens in a resource consent stage for stream erosion and mitigation.
I mean, will those developments be able to use the designated wetlands?
Yes.
They will be able to use
yes.
that. So, I mean, assumptions have been made as to what the maximum developable areas and so on are going to be at impervious surfaces. All of that's been sort of taken into account
yes.
in the volumetric calcs.
Yep, that's correct. And it does strike to a point of one of the changes in the designation for those wetlands around HHLs. They've done more design, they've changed things a little bit to better suit some of the requirements, and it ends up with a different footprint. And so we've reflected that in the...
Yeah, fine. But I mean, the volumes are constant. Obviously they're held constant.
Yes.
Okay, all right. Mark?
Thank you very much. I was curious about the point that I raised earlier, and I think you might well be the person who can shed a bit of light on it. Now, it was in relation to the location of a particular overland flow path that was required by the designation for the Greenway, which is not going to be able to be achieved through, as a consequence of further investigation here, and I've seen your evidence on that, and it seems water flows downhill. So, but I am curious about, and again, it might be something that we can have come back to us at a later stage, but I am curious on whether you're aware of how integral that is or otherwise to the designations, to the Greenway and its setup, effectively.
Yes, to a point. The overflow heading north into Mangahika, that triggers when at the very end of the Greenway at Ahoti Road there's a culvert that's there, and so when that blocks, or in a over-design event, it's designed for a 1 in 100 year RCP 8.5 climate change scenario. So when you get to a certain point where that is exceeded, then or that ultimate outlet is blocked, that's where that overland flow path triggers and then heads north, which really follows along the existing overland flow path that runs to the west of the alignment. And so to force that going down the actual road on the surface, you would push your road into the ground and have all sorts of consequences on it, triggering earlier at the upstream end, but also would drive it under the flood levels at the downstream end. So I'm aware of the condition from the Greenway, but how it actually arrives in practice is a different, would have a different outcome.
Thanks.
Just a query on the Mangahika ICMP model, which you've noted is pre-CMP, PCP, RCP.
Yep.
That will be updated, obviously.
Yeah, so council goes through a progression of updating all their flood models. The Te Rapa one, which is on the screen up there in yellow, has been updated to RCP 8.5. The Greenway for the design has the same, and when it comes through to updating the Mangahika in due course, that'll be needed. So if you were doing a detailed design for a delivery of or an assessment of effects, you would need to address it at that time. Yeah.
So is that going to make a difference in terms of current design for some of those wetlands, presumably? Or have they been sized sufficiently with a margin of error on top?
Yes, with the margin of error on top.
Okay,
yes.
All right. That's the question you asked. That's fine. All right. Yep. All right, Mr. Smith, I think lunch beckons, actually. Yes,
Yep.
yes. Good. Unless, Mr. Modoni, you've got a 5-minute one. Do you think Mr. Belbooth can do it in 5 minutes? We'll take him if you do.
Well, we can go back to the what I first stated was the order. I think of
Which
caused
is
enough chaos. We did have Mr. Abbott on urban design, which I mean I think would be relatively quick if you want.
5 minutes would be more than enough for urban design, I think, at this point in time. Welcome, Mr. Abbott.
Thank you. You feel the pressure of the room now.
So take a deep breath and enjoy the pressure. Yes,
Thank you.
Right.
Right, summary of my evidence. The urban and landscape design process to date, including design principles, considerations and responses, are captured in the project's ULDF, which is the Urban and Landscape Design Framework, Appendix J. The ULDF considers how the place and movement functions of each corridor will deliver the optimal urban design and landscape outcomes for the proposed designation in the wider structure plan area. When these outcomes are integrated into the design thinking of the corridor width and arrangement, they contribute to a safer, higher quality and integrated design that responds directly to their surrounding environment. In terms of the landscape and urban design issues raised by submitters, I provided a summary below. These are as follows. A, alignment of the proposed designation and the anticipated zoning of the area per the Rotokari structure plan, creating severance between areas of medium density residential zone. B, the assertion that the RSI will not deliver an attractive gateway into Rotokari North. And C, the lack of certainty relating to the interface between urban development and the arterial roads. I responded to these matters in my evidence and do not consider these submissions raise any significant issues and have not already been considered as part of the ULDF process. There is one submitter who has opposed the conditions proposed in the NOR, seeking instead that more focus be given to urban design matters. An updated proposed set of conditions are included in the attachment bundle, which articulate the wider objectives and purpose of the ULDF to relate to more than landscaping outcomes. In terms of the Section 42A report, there are no areas of disagreement between myself and the Section 42A report author, nor Mr. Hatting, nor do they recommend any changes, modifications to the NOR, nor to the proposed designation conditions in relation to urban design matters. I confirm that I support the project on the basis that the presence of the ULDF and its principles, together with the conditions proposed by Ms. Slatter, will provide an appropriate framework against which to deliver good outcomes for this project.
Thank you. And certainly that's how I read your evidence, really. It's just setting the groundwork, basically, for further design and further applications and so on as the process moves through. So.
Correct.
Yeah. Yeah. So you've got 2 more minutes to tell us anything.
Look at another witness.
Okay, I can hear lunch calling.
Right. Thank you.
Thank you.
Keep going if you wish. I can whip through landscape and visual if you like at this pace, or should we take a lunch break? Okay.
Time? What would you like?
45 minutes.
Yeah, okay. 1:15, back at 1:15 in that case. Thank you.
visual effects.
Kia ora. I think the project description has been covered, so I'll skip to paragraph 9. A landscape and visual assessment was undertaken to support the NOR for the RSI, addressing key landscape matters that include short-term, temporary effects on landscape character of the existing environment during construction, where the RSI is expected to be implemented within the context of the greenway and surrounding urban development, long-term effects on the landscape character of the anticipated future environment in which the Rotakoti structure plan area is expected to be or will become urbanised, landscape effects on the Rotakoti ridgeline character area, natural character effects of the project on wetlands and modified watercourses, and visual effects on key viewing audiences. Additional assessment was undertaken in response to Hamilton City Council's Section 92 request for further information. This included further assessment and clarification on the following matters: the proposal and construction information, existing and anticipated future environment forming the assessment baseline, temporary construction effects, natural character effects on wetlands and modified watercourses, and construction compounds. The requiring authority provided a response to the submission of Philip Ross Laird, landowner of 27 to 29 Burbish Road, concerning visual effects, of which long-term visual effects from the 2 viewing angles were assessed as being low and very low. The overall degree of landscape and visual effects assessed for the project are summarised as follows. Temporary effects on landscape character and visual amenity during the earthworks and construction will be low. Long-term effects on landscape character and visual amenity in the context of the future urban environment will be nil. And the overall effects on natural character will be very low. Proposed amenity planting and street trees along the verges and median islands of the project are anticipated to have a positive effect on the visual amenity of the future urban environment and through the existing Te Rapa Business Park. Vegetation will help to screen views of the RSI and will visually soften the appearance of the roading and vehicle traffic. So on the basis that temporary landscape and visual effects during earthworks and construction are low, reducing to nil in the long term, the project is considered appropriate within the current transitional rural environment and in the future urban landscape setting. Thank you.
I'm scanning. Mark, do you want to take any questions?
Thank you very much. I guess this comes to the role of the, I think the acronym is ULDMP. And I think in your evidence, you're of the view that that the conditions that Ms. Slater includes are adequate to manage the effects, whereas the council's expert in this area, Soanes, argues that it should be a broader framework that isn't concerned only with the kind of visual and urban design, but also goes into some of the other areas for which there are other management plans. And I'm just wanting to get an understanding from you about why the narrower focus is, why in your view that narrower focus is appropriate, and how these matters will interact, how you expect them to interact in practice.
So I don't see it as being in more narrow focus. A lot of the content outlined in our conditions are very similar to the recommended modified conditions. A bit of different terminology. A lot of the items listed as content have been moved up front as objectives in Ms. Soane's conditions, but it's still achieving the same outcome, in our opinion. Okay. Things like ecological matters, we refer to the ecological management plan, whereas specific ecological issues, lizard management and so forth, is stipulated as specific objectives in the proposed revised conditions. So, yeah, we feel that the intent is the same between both.
Okay, thank you.
So, thanks, Mr. Gamliel. I guess the question that just wondering how the, and again, I'm just beginning to think about the management plan frameworks. And because I don't understand how at this stage, how the construction is going to be staged or what sort of stages it might actually follow. But each of these management plans, and there's a general question here, each of these management plans is required in advance of any particular construction stage, as I understand it. It's not a one-stop shop in that regard. What sort of knits together between the stages? I mean, how's that going to work for consistency? Is this where the I guess the overall management guidance or the design guidance comes from, stitches it all together in your view?
Yeah, that's the purpose of the ULDMP, the Urban Landscape Design Management Plan. It's an overarching management plan which the aim is to achieve that consistency and address the same issues throughout each stage.
But the solutions to those issues might be different on each stage. How, I mean, I guess I'm thinking of worst case scenario where in actual fact, maybe a lot of the work doesn't start for 10 years and then it takes another 20 years before the final bit's put together or whatever because the greenway isn't developed or whatever. I mean, just thinking worst case scenario, not best case. Ideas, values and so on change over that period of time. Does the management plan provide sufficient flexibility for that sort of conceptual shifts? I mean, if you probably can't, but I can go back 30, 40 years in planning and see that the incredible changes of values that have come through over that period of time. So if you start plotting out a 20-year horizon, which you might be able to conceive of, things are not going to be the same. The value that we put on things, even on things like landscape and design, are going to change over that period of time. Is there sufficient flexibility in your management plan for that?
Just want to note that there's a bit of overlap here with urban design, which is separate piece of scope that Mr. Abbott had covered, but
yeah, but they may well come together in future.
Yeah, there is overlap. So I guess the answer to that is it needs to be comprehensive enough to attempt to have that flexibility. I'm not really sure how to answer that point about looking ahead 20 years in the future.
I won't have to worry about it, so that's another matter. But but I'd like to think that somebody had to worry about it. And I guess I'm really signalling from Ms. Slatter that this is just an issue for us to have a conversation about later on, because now we're not here designing a set of conditions which are going to be put into effect in the next 2 or 3 years. This is a long-term issue that we actually need to think about in terms of how those values change. So, all right, that's me just having a little bit of a head moment, so don't worry about it. All right. And I did check, I think, were they your diagrams which, I think you did contribute, didn't you, towards the profiles? the road section profiles, or not? Or not?
No, that was part of the
You
design
didn't?
scope.
Okay.
I'm familiar with it, but yeah.
All right, okay. But have you had a look at that to see whether in actual fact some of those principles that you've actually alluded to are actually reflected in those profiles?
Yes.
And you're comfortable with those?
Yeah, I mean, the key thing being street trees, which will provide some visual amenity and screening in the future.
Yeah, all right. Okay, yes, Mark.
Just one little follow-up on that particular point. There's some commentary in your assessment as well, and also reflected in some versions of the conditions, was the importance of the street trees and the reference to the continuous canopy. Can you just talk to us a little bit about where that comes from?
I think the continuous canopy comment has come from the TA recommended conditions. It's a great idea, but in reality, it's probably not feasible. There may be sections that can be continuous, but with crossings and bus stops and whatever else, there's going to be breaks.
Thank you.
I thought I'd finished, sorry. Just your paragraph 12. I mean, I'm taking from the way that you've framed all of those that your assessment assumes basically an urban build-out.
In the long term, yeah.
Because when you say that long-term effects on landscape character and visual amenity, this is your 12B, in the context of future urban development will be nil. Actually, there's going to be a sizable road there, and I would have thought that's probably, I mean, that is the landscape character from that point onwards, isn't it? It's not just nil, it's actually quite major, but not in an adverse sense, I think is how I'd frame that. Yeah. And the temporary effects, in terms of concluding the temporary effects will be low, this is as viewed from?
That's the overall rating based on looking at all the different viewing locations. Some were very low, some were up to low, moderate.
Yeah.
But overall.
But there would have been high points in there, presumably from those who are fairly close to where the works are going to be.
No, I didn't
None?
assess anything like that, no.
Okay, all right. Okay. Won't go into natural character, that's fine. Okay, good. Thank you, Mr. Gumley.
Thanks.
So I now call Ms. Webb on ecology. Ms. Webb, you produced a written statement dated the 27th of June of this year.
Yes, I did.
You have that in front of you?
I do.
And can I just ask you to read your summary of evidence and then answer any questions, please?
Sure. Good afternoon. My name's Claire Webb. I'm an ecologist that's worked on this project. My evidence summarises the ecological impact assessment that was completed that included terrestrial fauna, natural inland wetlands and watercourses. That assessment concludes that there is a low level of ecological effects on native terrestrial fauna, including birds, bats and lizards, and potentially high effects on waterways and natural inland wetlands and their associated fish fauna. The future consented environment, however, underpins the ecological impact assessment and assumes that urban development is well advanced and that the Rotokori Greenway is completed. This future consented environment was informed by Ms. Sladder's evidence. My recommendation is that measures to address adverse effects should be implemented prior to the commencement of and throughout construction. These measures should be incorporated and implemented via an ecological management plan to help guide the project and minimise construction effects. And although there is sufficient information in relation to the impacts on aquatic habitat, I've also recommended that a resurvey of the extent and values of these features within the designation is recommended to enable the appropriate determination of biodiversity offset or compensation requirements at the time of construction. I felt that this is necessary because the ecological values of wetlands and watercourses are highly variable, and in this landscape where we have this sequential development that may change across the horizon that we're looking at, and that to enable regional consenting requirements to be satisfied as well as inform effects management, that's the most appropriate response. Thank you.
Thank you, Ms. Webb. Can I just check with you, the resurvey that you talk about, is that a one-off resurvey or is that a resurvey prior to each stage being commenced?
It is prior to each stage of construction, and there's a consent condition that reflects that.
Right, yes. Okay, that's condition 29, isn't it? Yeah.
Correct.
Okay, all right. Okay, I'm good. Mark?
Thank you. I take it from your evidence that the proposed kind of broad methodology in terms of process is that there'll be as you've just talked about, a resurveying prior to the particular stage of construction, and if and in the event that there are, I guess, together with what's already known about the site, effects on effects that require kind of management in line with the effects management hierarchies. There's a process of obviously avoiding what can be avoided, but we know what the proposed development intention is the site is intended. And down this hierarchy we end up with the offsetting approach. And so I've got a couple of little questions about how that might work, especially given the timeframes that we're looking at and what's happening in the wider catchments. So can you perhaps tell me a little bit about, and I know you provided a little bit in your evidence as well about when you were addressing that question about how the additionality principle for the offsetting is going to be met, particularly for aquatic things, given that the greenway is required by another, is already a requirement. And so you've identified several sites that may be receiver sites or offset locations. So these sites that have been identified, how, in the absence of those ecological surveys, how do you know that they are sufficient in their extent or quality or characteristics to perform the functions of offsets for what might be within the locations that are going to be, impacted by construction?
I guess in the first instance, those were just indicative examples that there are other locations that are not the greenway itself that could be suitable in the future. But you are correct that's exactly why those resurveys required at that time, not just for the impact sites, but for any potential mitigation or offset sites. It does need to be commensurate with the values at that time, which makes it very difficult at this point in time, other than to make some assumptions around the general quantum that may be impacted. And I think that's probably the most appropriate way forward. Otherwise, you may have a changing landscape that then locks you into mitigation sites that are either no longer appropriate or are not commensurate with their level of effects. Mm. And that's the whole purpose of the pre-survey. Yeah.
Can you perhaps talk to us a little bit as well about, I think I'll find it to make it easy, paragraph 38E, which talks about the best practice methods for metrics used for establishing the quantums. And I think one of the areas that's been problematic in this particular location you mentioned, or one of the species that's been a challenge in this location in the past, and you mentioned it at sea, is black mudfish. Which,
correct.
And so, in terms of what are the, because I know there's combinations of extent, condition, habitat restoration, etc. For that particular species, what's the, how does what are the types of metrics that you're referring to, these metrics that you refer to in E, how do they play out for something like that?
Yeah, it's quite complex. So in terms of those metrics listed, particularly the stream ecological valuation, that's a tool used specifically to compensate for habitat loss, not necessarily species effects. So often we find the habitat may not be protected and therefore no compensation is required, but the species itself is of course a protected species as an at risk. And as such, in terms of, for example, if it was a protected habitat, you would use those tools to quantify the extent, so usually in linear metres or area, hectares of habitat required to support a population that you find at that impact site. So that takes a bit of survey work. That needs to be translated into somewhere else. And how that works is that you would look for that appropriate amount of habitat in another location that's suitable for those species and kind of go from there. Does that answer the question?
Yeah, I think it does.
It's sort of a mathematical and professional judgment assessment.
And using the habitat as a proxy rather than the presence or absence of the species itself.
Yeah, and there's a couple of different ways you can do it, and I think it's at that point you would, as an ecologist, decide whether you're looking at like linear metres of habitat or perhaps a biodiversity offset and accounting model would be more appropriate, and that would enable you to account for carrying capacity and the population abundance of your impact site. So it's at that point in time that you kind of make the call depending on what you found present at the time of impact.
Okay, thank you.
Bit of a hypothetical question for me on this is, by tying the survey and the management plan to stages of work, is there a risk that in actual fact, by not having an overall plan, that in actual fact, as the stages progress through, that in actual fact you're not capturing the ecological values that were there at the start of the project, because as you move, the ecology moves as well, so that by, you basically, I mean, imagine moving from north to south in 5 or 6 different stages, for example. By the time you get to the south end, what you're concerned about may actually have moved off because they've been disturbed by the previous stage. I mean, is there a risk of that?
I understand what you're saying, but I think actually ecology is quite localised, particularly in this environment where we do have sort of these hot spots because it is a highly impacted environment already. So I guess I'm less concerned about that.
But couldn't you identify them now? Wouldn't it make more sense to have a baseline across the project?
We do have a baseline as part of the original ECIA. I guess given that, you know, as you rightly pointed out before, we're talking about a horizon of potentially beyond 5 years. In context of the future urban zone, I think we'll see quite a large shift in what remains by the time the road comes along. And because of that, I think it's whatever that baseline is now may actually be irrelevant in the next 3 to 5 years, even as soon as that.
But might you not also get recruitment from the Greenway if the Greenway is done well?
I think that would be a possibility, but in terms of the timeframes that you would look at for the Greenway to establish itself, I think it's quite beyond 5 years. We're talking 10 to 20 years before, you know, any sort of recruitment would happen.
All right, no, happy with that. All right, thank you, Ms. Webb.
Thank you.
I now call Ms. Keith on archaeology.
Hi. So I'll just read my executive summary. The assessment involved a review of historic documents, archaeological data, consultants' reports, Hamilton City Council plans and a field visit. Based on this research, the assessment determined that there are no known archaeological sites, features or deposits which will be affected by the proposal. It is recommended in the assessment that there are no known reasons to alter the current proposal based on archaeological values, and there is no known requirement to apply to Heritage New Zealand for an authority to modify or destroy potential archaeological site. There are no new archaeological sites recorded within the New Zealand Archaeological Association database since I compiled my assessment within or close to the footprint. There are no submissions received related to my discipline. Mr. Nicholas Cable's Technical Specialist Memorandum on Archaeology is in agreement with my conclusions and supports the recommendations made. Hamilton City Council's Section 42A report is in agreement with my conclusions. It states that there will be no adverse effects on archaeological values. I recommended a minor amendment to the Section 42A report author's condition 24.2 to insert the words suspected human before reference to remains. Thank you.
Anyway, yes.
So it's an academic point.
Yeah. No, that's all very clear. Thank you, Ms. Keith. Appreciate that.
Thank you.
Holly Scott on contaminated land is next. Scott, you produced a statement dated the 27th of June of this year.
Yep.
And you have that in front of you?
Yes.
Just read the executive summary, please.
Awesome. Thank you. Yeah, my name's Holly Scott. I prepared the preliminary site investigation and my evidence summarises that. So I'll start from point 6. The PSI identified 14 sites within 100 metres of the project that have had hazardous activities or industries list activities identified with a more likely than not level of certainty and are subject to the National Environmental Standard for Assessing and Managing Contaminants in Soil to Protect Human Health regulations. The PSI recommended that prior to soil disturbance in the identified areas, further contaminated land investigation be undertaken to assess the risk to receptors and that a contaminated soil management plan be prepared to appropriately manage soil disturbance and support contaminated land-related resource consents for the project. Matters required to be covered by a further contaminated land assessment under the NESCS will be subject to a separate consenting process prior to construction of the project. By following the above process for further investigation and subsequent management, I consider that the effects of contaminated land matters relating to the proposed works can be appropriately managed. The sources of potential contamination identified by the PSI are expected to be of a nature that can be managed by industry standard processes, such as management and/or remediation, should contamination be identified by these further investigations proposed. The PSI has not identified any reason that the alignment should need to be moved or is likely to result in effects arising from contaminated land that cannot be appropriately managed.
Well, as you say, there's a parallel process to be gone through. Anything? Yep. Okay.
Thank you. Just one very small question, and it relates to the the two possible consent pathways for addressing the contamination, any contamination issues as they progress, either staged or global. For which pathway do you consider preferable for a project like this?
I have seen both done, and it depends on the stage rollout of the works. Sometimes having a global can be beneficial because then you can have overarching management planned for, and then the investigations are rolled out per stages of works.
Thank you.
Just curiosity, how far does the WRC Hail register go back? How far does it take you back?
I can't recall the exact dates off the top of my head because it's in the rural area. I think it's just whatever they have on file. I'm not sure of the date.
Okay, all right. I mean, that's apropos of nothing because if you find, well, what's the process now for detection, if you like? Is it a deliberate process from here on out, or how does that actually work? How do you discover soil contamination now?
Once the stages are to be rolled out, each of these hail areas, as they're to be disturbed, there'll be a first review of the PSI and any further information since then, and then a targeted investigation for sampling. And
so each stage will be defined as a potential hail or something to that effect, will it?
Yeah, so each hail will be investigated for the contaminants of concern.
Sorry, let's be clear. When you say each hail, what is a hail?
One of those 14 sites identified with a potentially contaminating activity.
Okay, so it's only those sites. There's not a broader consideration as to whether there might be contamination outside.
The process for determining potential contamination is based on those hail list activities, which have been identified now, but pre each stage of works there's an opportunity to review to check that nothing has changed.
Okay, all right. So the requirement is only on sites that are registered. Okay. All right.
Thank you.
Thank you, Scott. Mr. Balbooth on acoustic matters. Oh, don't do it to him twice. Now, Mr. Balbooth has produced evidence in chief on the 27th of June, and he's also produced a supplementary statement. So we'll go first to your 27 June statement, if we can, Mr. Balbooth.
Thank you. Kia ora. Thank you. It's a pleasure to be here. I'm James Balbooth, and I lead the acoustic assessment for the OOctober Strategic Infrastructure Project. Starting with my primary evidence executive summary. My evidence for the RSI provides an assessment of construction and noise vibration, updated operational traffic noise predictions and responses to relevant submission points, and the Section 42A report matters, along with recommendations for designation conditions. On the matter of construction noise and vibration are predicted to be generally compliant with relevant New Zealand standards, and I recommend a comprehensive construction noise and vibration management plan based on New Zealand Standard 6803 is effective to effectively manage and mitigate potential adverse effects.
At some point?
I am certainly hopeful. I understand that there are some murmurs and a committee to forming. provided that construction activities are appropriately managed through this recommended CMVMP, I consider that construction noise and vibration effects will be reasonable. Moving to updated operational traffic noise predictions, following the release of the latest Waikato regional transport model, which my colleague talked about earlier, and updated New Zealand Transport Agency guidance on road surface corrections, which came out in February 2024, I've predicted new operational traffic noise levels. For the protected places and facilities identified adjacent to altered road sections, my updated model demonstrates a reduction in future noise levels. My primary evidence talks about a level in there, but I will come to talk to that in my supplementary. And this is compared to the do-nothing scenario. And that noise levels remain within the preferred Category A of New Zealand Standard 6806, and that standard doesn't apply to this project. For the single PPF adjacent to a new road, there'll be an increase of 8 decibels, which is predicted, and the resulting noise levels also remain within 6806 Category A, meaning no specific mitigation measures are required for that receiver. And overall, I've assessed the operational noise effects will be acceptable and generally neutral for those 4 identified PPFs. In response to the submissions, I've addressed concerns raised by the submitters regarding noise and vibration. My assessment confirms that the operational noise levels are acceptable and often reduced in comparison to the existing environment, and traffic vibration from a new well-maintained road is unlikely to cause adverse effects, and construction impact will be managed via the CMVMP. In response to the Section 42A's report, the specialist evaluation of noise and vibration in the Section 42A report largely concurs with my A&E's initial conclusions, particularly regarding construction noise management. The next 2 paragraphs will be updated through my supplementary. So where I say that the Section 42A reviewer hasn't had the opportunity, they now have to review my updated traffic noise calculations, and there's been some movement on their position with respect to construction noise and vibration management scheduled for 2 receivers, well, for 1 receiver at 27 and 29 Burbush Road. So the recommendations in my primary evidence are that I recommend that the 4 identified PPFs within 100 metres of the proposed road alignment be formally recognised in an appendix to the designation conditions. Are you happy for me to move on to my supplementary? Thank you. So just reading from the executive summary. Just at this juncture, I'd just like to point out that there's a typographical error in this, in Table 3 of this, just following Para 20. The numbers at 244 Te Kōwhai Road should be 65. Both of them should be 65. My apologies for that. A minor error was identified in my noise model, which had omitted a section of Te Kōwhai Road. This resulted in an incorrect do-nothing noise level prediction of 52 for the property at 244 Te Kōwhai Road. The amended model, which includes the omitted road section along with updated traffic volumes and road surface data, show the correct do-nothing noise level is 65. Crucially, the correction is inconsequential to my overall findings in my original assessment. The project's effects remain unchanged and no new noise mitigation is required. Ms Young, who is the Section 42A expert, agrees with the updated predictions and the report's conclusions. In response to Ms Young's recommendations on designation conditions contained in her addendum memorandum to the Section 42A report, I consider that her proposed amendments to conditions for a schedule to the CMVMP is process focused and not consequential to either noise levels or potential noise effects. Ms Young also recommended updated wording to the operational noise condition. I've proposed additional wording for the operational noise condition to improve the clarity whilst retaining the flexibility intended by the Traffic Noise Standard 6806, specifically regarding the best practicable option. I maintain my original conclusions outlined in my primary evidence that construction noise can be appropriately managed and the project operational noise effects are acceptable and neutral, falling within established limits without needing mitigation.
Thank you, Mr. Belbooth. Just the last matter you touched on there in terms of your paragraph 30 of your supplementary and the amendment you're proposing. Can't quite see the logic of Roman 20. What's the logic for that? So in paragraph 30. I mean, I thought you were indicating that in actual fact there is no effect on the PPFs.
There are no effect, and they are in category.
So why a suitably qualified, experienced person to develop a detailed mitigation option?
So, if the designation were to be granted and a specimen design created, and there were to be some changes or alignment differences or matters of that nature, it would be prudent to investigate what the noise levels from that proposed design would be. And really, Roman 20 is a step into Roman 30, which is a suitably qualified person should develop the detailed mitigation options, and then should those detailed mitigation options present that there is a change in category, then they need to demonstrate.
So what you're saying is there's a base mitigation document lying there in the event that there's an exceedance and you need to access it. That's what it is.
Yes.
Okay, I hadn't read that way. Thank you. All right. In your primary evidence, you take a deductive approach to the noise, i.e. it's less than. Is what's currently experienced reasonable? I mean, obviously a reduction is fine, but if it's already unreasonable, then that doesn't count for much. So just a question.
Yeah, yes, it is reasonable. So the
and that's reasonable in terms of
what is
the standard, or
yes.
or in terms of
the standard, yes.
Just in terms of the standard. Because that's only a guideline, isn't it? I mean, the altered roads and new roads thing is a guide. It's not a prescription. And I think you then don't you apply your assessment of the actual noise or the predicted noise within the framework of that guidance on the roads?
Yes, the road noise standard acknowledges that the existing environment has a degree of noise associated with it. It anticipates that the noise environment will change in the future, given the propensity for growth, more cars on the road and an increased traffic noise level, and subsequently determines criterion that are reasonable based on those existing environments.
Yeah. All right. No, thank you.
Thank you. It's kind of a follow-on from the chair's earlier question, which was how these things shift really. And you mentioned that Roman 20 gets called in if something changes, basically. Which was really my kind of part of my question in terms of the noise criteria categories. What kinds of things would cause a category change?
Yeah, I do speak to this in my evidence. Forgive me, I won't be able to recall the para immediately. It might be just prior to this. It's highly unlikely that there will be a category shift on this project. And just to give some background, my recommendation is in response to the Section 42A's recommendation, who is seeking better clarity and better enforceability. And in doing so has prescribed something that is quite rigid. And in my response, I'm saying, I agree with your wording, however, to give it the flexibility that the standard intends, I'm offering 20 and 30 as a, Roman 20 and 30 as a solution for that. To slightly digress from your question there, what would actually cause a change might be a significant realignment or a selection of road surface because of other factors outside of noise that would be required for safety or what have you that would change the noise level. Yeah, it seems at this stage of a project that it's unlikely, but there are numerous projects that myself and my firm have worked on where over the course of time, through detailed design, things shift slightly and the category can shift. So it's really about ensuring that there is an opportunity to review that and ensure that the intent of the standard is met.
What is the threshold between A and B, for example?
For an altered road, I'm going to refer back to my notes because it's a bit of a complicated situation.
I mean, I'm assuming it's simply a metric. It's simply a level of decibel.
Yeah, it is.
Weighted or whatever.
For an altered road, it's slightly different. It depends on the existing noise environment. So, yeah, that's right.
Is what that metric is?
Yes, I can. Sorry, I'm on the spot.
That's all right. We don't have the benefit of 6806 or whatever it is, unless we pay for it, apparently. Yes. I mean, we're happy to, if the requiring authority is prepared to finance our standards.
So the just trying to find the most succinct way of putting it. Forgive me.
I mean, if you want to just put some thoughts down on a piece of paper overnight and give it to us, that's fine. Rather
Yes,
than taking
thank you.
it now, that would be that's fine.
Yeah,
As I say,
I don't want to put you wrong on the spot.
I would hope you wouldn't want to put us wrong. But, yes, right. No, it's just that if you're saying it's unlikely to occur, we need to have an understanding as to how far below that pivot point we actually are. So that's helpful.
Yes.
Thank you. I mean, you do the same for B and C as well. If you can just give us a cascade of those.
Yes,
that would
absolutely.
Thank you.
Thank you.
That's it, except for Ms. Slatter in relation to planning, so are we done? Yes.
That's right. Ms. Slatter, welcome. What are you going to do to us?
Well, I'll start at the beginning, shall I?
Oh, no, please don't do that. That could take us a while.
So I can start with the exec summary of my evidence in chief and then move into my supplementary. All right, well, tēnei te mihi kia kōrua. He uri tēnei no Waitaha Kātima Moe Kaitahu ko Melissa Slatter taha kūkua. I'll start at paragraph 8 in my exec summary. So the works and the proposed designation are reasonably necessary to achieve the RA's objective for which the proposed designation is sought. The proposed designation will provide a mechanism for the RA to protect a sufficient area of land to construct, operate and maintain the strategic transport and 3 waters infrastructure necessary to enable the planned growth of the Rotorua structure plan areas. An assessment of environmental effects of the proposed designation has been undertaken. The technical specialists have concluded the project has many positive effects and with appropriate mitigation, temporary construction and permanent operational effects can be managed to acceptable levels. Many submitters are supportive of the project. Those matters of concern raised by submitters can be addressed by an updated set of proposed conditions which provide a pathway for the integration of adjacent land use with the project during detailed design, together with the development of a suite of management plans to manage temporary and permanent effects. The Section 42A report and supporting assessments, technical assessments, are supportive of the proposed designation. The conditions proposed by the Section 42A report have been carefully considered by the project team. I think I'll stop there and move on to my supplementary because we pick up the thread of the various conditions as we've gone through.
Before you move off there, I meant to ask this question earlier. In paragraph 9, you talk about construct, operate, maintain the strategic transport and three waters infrastructure. It actually doesn't do the three waters infrastructure. I mean, it has some stormwater elements, doesn't it? But is it intended there be more than that?
Yes, so there will be wastewater and water in the corridor as well.
It will be in the corridor, but that doesn't need to be shown, obviously, at this point in time, but that is intended.
Yes.
Okay, thank you.
All right, so moving across to my supplementary.
Just before you go to your supplementary, there was also rebuttal evidence that you produced, which I don't know that needs to be read. That was just a series of responses. It was relatively brief, but just responses to submitter evidence. So I think we could probably take that as read, but just checking with you. No, so I think we can. Yep.
Okay, so I'll start at 4, scope of my supplementary. So the purpose of the supplementary statement of evidence, which is provided on behalf of Hamilton City as the requiring authority, is to provide commentary on the final set of designation conditions proposed by the RA as attached to the Memorandum of Council for the requiring authority dated 30th of September 2025. This statement addresses several points that have arisen in the Section 42A Reporting Officer's Addendum report and matters arising from discussions directly with the reporting officer. The statement has been provided to support the hearing panel to make decisions on the NOR and to describe the background to, the intent of, and some detail around the final conditions proposed by the RA. My statement covers the following 7 topics: the background to the revised conditions provided in my primary evidence, engagement with mana whenua. Keep going. Yep.
Keep going, the exec.
So, exec summary.
Yeah, thank you.
Right. The revised conditions attached to my primary evidence are founded on strong principles through the Te Tupu Ngātahi Supporting Growth Alliance and represent a good foundation for conditions for this project. The final conditions build on that foundation also. The RA values the partnership with mana whenua and Waikato Tainui on this project and appreciates the willingness of mana whenua to co-author conditions to enable ongoing opportunities for them to exercise kaitiakitanga over many aspects of this project that interest them. The final conditions reflect the outcomes of that engagement. The addendum report proposed significant changes to the revised conditions. These proposed changes have been carefully considered. Where these improve clarity and better deliver on the intent of the condition, I have brought them across into the final conditions. However, there are several proposed amendments that I do not support due to the unnecessary complexity or inconsistency in implementation they introduce. In my opinion, the project is consistent with the relevant statutory instruments and Part 2 of the RMA, and the proposed designation can be confirmed subject to the proposed final conditions. Background to the revised conditions. So the revised conditions appended to my primary evidence have a strong principle-based foundation from Te Tupu Ngātahi Supporting Growth Alliance and Auckland Transport Designation conditions. Those conditions were the product of a work stream involving a multidisciplinary team of experienced planners, legal professionals and subject matter experts familiar in the implementation of transport projects. Those conditions were applied consistently across the suite of 70 notices of requirement through 8 RMA hearings during 2022 to 2024 on behalf of the Alliance. While I was not involved in that project, a number of my colleagues were, and I have discussed the project with them. I understand the principles on which these conditions were formulated and am very comfortable using those principles as the basis for both the proposed revised conditions and the later iteration in the final conditions.
I had an annotation at that point, and what are the principles is the annotation. What are they?
So the principles were really, because of the long implementation, the principles were in this case to be applied fairly consistently across a large number of projects because it spanned a large geographical area. So ease of implementation. Outcomes focused was one of the key principles, particularly around the development of the management plans. And good, I guess, alignment, partnership with mana whenua. So there was a lot of work with mana whenua to co-author and develop those conditions. There was a principle around engaging with the parties, so multiple stakeholders involved, and so they wanted to make sure everyone was treated the same, so there was no distinction, with the exception of partners with tangata whenua, mana whenua, there was no distinction in stakeholder categories. So that was quite a strong principle as well. So everyone was treated equally, and you didn't, while you may have people that come to the hearing with very specific interests now, in 20 or 30 years' time, that interest may be lost in translation. So the ability to make sure people, the issues were able to be captured rather than the individuals.
On the first one that you mentioned, the ease of implementation, just a little bit more about that. What does that? I mean, that's capable of a lot of different meanings in terms of what it actually means. What does it mean to you?
For me, it's about, I think, adopting an approach that can withstand an individual. So as a planner that may be sitting in this seat right now, and I'll have a certain understanding of what's coming, of what was meant by a condition, that can be picked up and easily understood and implemented by another planner. So something that's written in quite plain language and
so clarity of interpretation and so on.
Okay, thanks.
Okay. I just didn't want it to mean ease for the proponent.
No, yeah.
Right. Okay, thank you.
Carry on at 14.
Yep.
Okay, so the project team commenced engagement with the then mana whenua collective Te Hao Te Whenua o Kirikiriroa in 2020 through a series of hui which culminated in the preparation and endorsement of the Rotokauri Arterial Network Cultural Impact Assessment 2021. This built on the earlier Rotokauri Greenway Cultural Impact Assessment 2019. In 2023, the NOR was notified with draft conditions to give effect to the 2019 and 2021 Cultural Impact Assessment. Mana whenua did not lodge a submission on the NOR. In May 2025, the Section 42A reporting officer recommended an alternative set of conditions to those draft conditions contained within the NOR, which was said to be more appropriately manage the effects of the project on mana whenua values. The RA considers mana whenua as a partner in the delivery of this project. The 4 weeks between receiving the Section 42A report and preparing my primary evidence in response to the Section 42A report did not give me sufficient time to properly re-engage with mana whenua to achieve co-authorship of the revised conditions in my primary evidence. As a result of this, I proposed a placeholder condition 9 to be completed with mana whenua in my primary evidence. The project team then recommenced engagement with mana whenua to co-author a revised set of conditions to protect their interests and enable continued participation in this project. As Ms Kukutai has shared, hui were held on the 27th of August, 10th of September, 22nd and 25th of September this year. At the 25th of September hui, agreement was reached between the project team and mana whenua on the final wording of the following conditions. So you can see them specified there. At 21, I talked to the sequencing of the proposed final conditions, and this is a really important part. We've got a figure up on the screen here and is also in our bundle that describes the sequencing of the management plan. So if you're okay, I'll just quickly...
Can I just pause you there for a moment? Because I just want to ask the question of your paragraph 20. So what you're saying is that these A to H or A to G and then table 8, table 1, the specific wording or all of the wording on those conditions has been agreed between the requiring authority and the Manawhenua collective.
Yes.
What does that mean in the event that we want to change some of those? I mean, I know we have the ability to do that, but I guess the question is what undertaking has, if any, has been given to the Manawhenua collective in the event that well, we're not even recommending. In fact, it's not even a question, is it? Because we're not even recommending this time, so there isn't actually a pause. But I'm just wondering whether in actual fact, if we decide as a consequence of the conversation we have tomorrow, for example, that in actual fact we think there should be some changes to the conditions, do we need to actually provide a process for the requiring authority to check that out with, and or us to check that out with the Manawhenua collective?
I think as a project partner, we would be fairly committed to having a conversation with them about any changes, particularly if they relate to matters where we have co-authored with them.
That assumes that you know what changes we're going to make.
Exactly, and I don't.
I guess I'm just throwing that out there for a thought, Ms. Madan. You might want to come back on
Well,
that.
I mean, I can answer it, I think, now, which is to say that if there was a signal that there were departures or intended departures from these conditions which have been through the process that Ms. Slatter has described, I think if the panel was prepared to give me the signal and we could get an understanding of the intended direction of travel, I would then seek some pause in the process while I circle back to our Manawhenua partners and advise them of the position and give them an opportunity to provide some form of response or comment or something of that nature. So I would ask for that pause in terms of the recognised partnership approach that we are taking here.
Yeah. And I think we'd be quite relaxed about doing that, so let's signal that at this point. Okay.
Thank you.
And by that, I don't mean that we've got some ideas for changes at this stage. We're not there.
No. Thank you, sir.
So figure 2 on your screen there essentially just steps out the process, and this might help with some of the management plan queries that have been coming across as well. So if I can just quickly step you through, at the beginning of this figure there's a confirmation of the designation through to the funding, 2 dots in the timeline. So this is a timeline that just indicates the importance of the sequencing of those conditions. So not a lot happens in that first stage. We would just be responding to inquiries, and we've got a couple of conditions. Condition 2 related to project information, and condition 3, the land use integration process condition, which I'll speak to shortly, would be active or enacted if need be in that early stage. Then once funding's secured, probably before about 12 months out, the Manawhenua Ki Roto Kauri Forum would establish, and at that point they are invited to develop their Manawhenua Ki Roto Kauri cultural management plan. And so it's quite important, that's in condition 9, that that group gets established early on and develops their cultural management plan, because the intention for that is then to influence the urban and landscape design management plan. So that's sort of 6 months out we would start to develop up that ULDMP. It also is important to note at this stage that the cultural monitoring plan has been pulled out and identified early there as well. And that's quite deliberate. The Manawhenua collective have got a real interest in cultural monitoring, and to the extent that they want to be able to adequately identify, resource and train those monitors well in advance of project works was something they wanted to lift out. So all of that happens in the pre-detailed design stage. The urban ULDMP continues to be developed right up into the start of construction, but because of its direction setting that's come through from previous witnesses, it will still have a very heavy influence on the cascading or the following management plans listed there: the environmental management, construction, traffic, noise and vibration, and importantly for mana whenua, the ecological management plan. So that just sort of gives a bit of an outline on how the cultural management plan really will inform the ULDMP, and then it will carry on to inform the rest of the rest of the management plans. Okay. So that sequencing is really important, and I think I just want to sort of just take a bit of time explaining that in the condition set, because this is perhaps one of the key differences between the RA set and the TA set. So as I just carry on at point 21 there, condition 4 of the final conditions establishes the rōpū, which then enables the delivery of the cultural management plan. This is a necessary precursor to condition 10, the landscape, urban and landscape design management plan, which sets that foundation for incorporating mana whenua perspectives and cultural expression prior to and throughout the detailed design stage. This also enables early development of the cultural monitoring plan. At 22, the sequence is intended to be deliberate to allow for the incorporation of mana whenua perspectives in all of the management plans, and this occurs in a cascading manner. Moreover, the conditions invite mana whenua to continue to participate in the development of these management plans as a project partner. On the basis of the engagement the RA has had with mana whenua and Waikato Tainui, I'm satisfied the proposed conditions will appropriately provide for mana whenua to exercise kaitiakitanga over those aspects of the project that are of particular interest to them. And for those reasons, I do not support the Section 42A reporting officer's conditions 20, 21, 25 and 28 to manage cultural effects. Support for conditions from submitters. It is important to acknowledge that the wording of the proposed revised conditions and subsequent final conditions, which build on the revised conditions, reflects the outcome of engagement between the requiring authority and submitters, some of whom expressed support for the revised conditions in their statements of evidence. A number of conditions, so 3, 4, 17 and 23 and Table 1, are examples that have been drafted with submitters, and I consider it is important to maintain a degree of drafting consistency in addressing their issues. Furthermore, they may be relying on the proposed revised conditions being confirmed, and that may have influenced their attendance or otherwise at today's hearing. For that reason, the final conditions remain faithful to the foundation laid by the revised conditions. Proposed amendments. I've reviewed the Section 42A reporting officer's proposed conditions in Appendix J to the addendum report, and where there are changes that may improve the purpose or the intent of the condition, I've included them. However, a number of amendments proposed by the 42A reporting officer introduce a level of complexity to the condition or set of conditions, or reflect a drafting and sequencing preference that is inconsistent with my own. In these instances, I have not brought those changes across. So the following sections just talk to some specific planning commentary around the conditions and some of the differences you may have identified. So condition 3 is a land use and integration process condition. So condition 3 of the final conditions prescribes a land use integration process. This condition is offered up by the RA to respond to matters raised by submitters who are proposing to undertake master planning of adjoining land and seek to integrate their development with the designation. This may include matters relating to urban and landscape design, stormwater management and transport connectivity. Importantly, this is a process which occurs prior to implementation of the designation. The condition provides an avenue for landowners undertaking master planning to engage with the RA over their master planning, which is appropriate. All other inquiries can be addressed by the mechanisms established under Condition 2, Project Information. In my view, the changes proposed to Condition 3 by the Section 42 reporting officer introduce an unnecessary complexity by defining different categories of stakeholders, which then clutter the condition and interpretation. The condition also confuses the intended function of the project liaison person, which is a defined term. This term is reserved for conditions 9, 19, 20 and 24, specifically during the construction works phase. Condition 4 and 19.
Just before you move off, that, this doesn't seem to be stage relative. It seems to be a one-off. The reason for that? I mean, again, I'm thinking some of these stages might be 15, 20 years away.
Yes, yeah. It's really, it's at that time where because we're getting inquiries, or the RA is getting inquiries now by a number of adjoining master plan developers. So the intention is the RA would share whatever information they've got at the time. So at the moment, it's fairly conceptual, it's the NOR level of detail, and if the adjacent landowner through their master planning wants to pick that up and move into a greater level of detail, then that's their prerogative. Yeah. Okay.
Really is geared towards those who are currently in the active process of master planning.
Yes. Yeah. It's not us initiating it. It would be them coming to us. Yeah. Okay. So there are two conditions that specifically address stakeholder engagement, distinct from project partner engagement, and those are condition 4, stakeholder communication and engagement, and condition 19, the stakeholder communication and engagement management plan. Condition 4 is to be read in conjunction with Table 1, Project Partners and Stakeholders Table. As discussed in paragraphs 21 and 22 above, the sequencing of the conditions is deliberate. Condition 4 appears early in the condition set as it provides for a review of Table 1 prior to the project detailed design commencing and draws attention to the parties who will be engaged and the matters over which they will be engaged on. By way of example, Waikato Regional Council has indicated it wishes to be engaged during the detailed design stage to discuss public transport infrastructure and flood overflows on the network. At this time, they will also be engaged on matters relating to the management of downstream stormwater volume increase in the Mangaheka, Rotakoti and Te Rapa catchments. Later in the project, prior to construction, they will be given 12 weeks notification of the disruption to the PT services during the construction period. So that table sort of steps someone picking this up through the various elements of interest that that stakeholder has and when might be the right time to engage them. So yeah, we've sort of done a lot of that heavy lifting early on so that in time it gets picked up and it's easy to understand. The objective of condition 19, the Stakeholder Communication and Engagement Management Plan, is to provide timely and effective communication about the project to mana whenua, stakeholders and the public throughout the construction works phase. Condition 19 deliberately sits in the suite of management plan conditions as it is designed to address engagement matters during construction works. The Section 42A reporting officer proposes to bring these two conditions together into a single condition 18, which in my view is inappropriate and I do not support it. Condition 4 sets up a process to engage with stakeholders and 19 sets out how the process of engagement during construction will be implemented. Bringing these two conditions together potentially risks these engagement activities occurring out of sequence, missing the opportunity to engage with stakeholders early during the detailed design process, and it may be potentially confusing to implement when all the engagement is sitting in the management plan suite of conditions. I do, however, support the inclusion of Figure 1 submitted properties, and I agree in part with the proposed additions to Table 1 and have tracked further changes which respond to our recent engagement with mana whenua, Waikato Tainui and the Regional Council. I don't support the amalgamation of those two conditions. Shall I carry on? Record of engagement. The 42A reporting officer introduces a new condition 19, record of stakeholder engagement, consultation and communication. In my view, this is unnecessary. There are already instances where a record of engagement will be produced and made available to the TA during the outline plan stage. For example, Condition 4B, stakeholder communication and engagement, Condition 18C, management plans, and Condition 21, complaints management process. These processes are deliberately kept separate as they occur for different reasons. I don't support the reporting officer's proposed Condition 19 to restate the need for and an engagement record. Detailed design matters. In the final conditions, Condition 7, geotechnical investigations, and Condition 13, responding to peer reviews, and Condition 14, flooding, provide for specific matters to be addressed during the detailed design stage of the project. I agree in part with the 42A reporting officer's recommendation to provide this information at the outline plan stage. However, this will only be to demonstrate compliance with the condition and for the TA to review and comment within the limitations of the outline plan process. Therefore, I have proposed the addition of the wording below to be applied consistently against Conditions 7, 13 and 14, which is the addition of the clause, compliance with this condition shall be demonstrated in the outline plan. So it was more of a consistency of drafting piece. Condition 8, emergency vehicle access. This condition is provided to bring specific attention to the provision of reasonable access during detailed design of the proposed cross-sections of the various transport corridors. Although not a submitter, this is a matter identified in Table 1, Condition 4, to be discussed with Fire and Emergency, the Police and St John's. I do not support the Section 42A reporting officer's proposed wording of best practicable access, as this may commit the RA to an unnecessarily higher standard of design than is needed, or it may compromise other project objectives and factors, including cost. And I think we've heard today there are other elements. Mr. Hick talked about the different treatments that you would give mid-block on different cross-sections, and how you might achieve that will vary depending on the cross-section. And as Mr. Maldoni suggested, safe and passable access is the goal. We're not here to stop emergency vehicles getting through, but it's the threshold of reasonable versus best practicable access that is at stake here. So other than a minor drafting edit, I don't propose any further changes to Condition 8. Condition 18, management plans. So the management plan condition sets out the requirements for all management plans in terms of how they are to be prepared. As with the outline plan Condition 36, the management plan condition recognises that management plans may need to be prepared in parts or in stages to address particular activities or a construction stage. The management plan objectives have been drafted to be largely outcome focused. This approach recognises the longer implementation timeframes of the designation of 15 years and the likelihood of a change within the receiving environment. This approach means that the management plan conditions A, express an outcome to be achieved as an objective, and B, identify matters to be addressed to achieve that objective. By way of an example, in Condition 23, the objective of the Construction Traffic Management Plan is to avoid, remedy or mitigate, as far as practicable, adverse construction traffic effects. The CTMP then sets out the matters that shall be addressed in the development of the management plan to achieve the objectives, such as measures to ensure the safety of all transport users. Due to the potentially long-term implementation, the objectives are intentionally broad to enable flexibility in the management plan preparation, while appropriately avoiding, remedying or mitigating the relevant effects. And I think this helps to respond to your question earlier, Commissioner Hill, around the potential change in values. So having a fairly broad objective will enable those, those values to be, because the condition is, the objective is outcomes focused rather than specifically detailed, it enables you to be able to pitch and adjust your assessment of how you might manage those effects if you've got a broader set of objectives to start with. It just brings more flexibility, I think, because we are looking at a longer period of implementation, and those values may well change, and how you will respond to them may well change.
We'll probably have this conversation tomorrow, but I guess the question on the other foot is what happens when you disagree on what that means and how you're going to achieve that. If you're so broad in the, I guess, in the sub-paragraphs to your objective, then you set up although you'll be, in a sense, you're talking to yourself in this particular instance, because council's just talking to itself. But there is a risk then that in actual fact you have a fundamental disagreement on the way in which you might achieve things. How's that to be resolved? I mean, I know the outline plan process is a process, but you don't want to set up a skeleton that where you can see that at the end of the day you're going to go to court to fight it. In terms of the appeal on or the lodging an appeal on the outline plan.
Yeah. And I don't think that's ever happened in the history of the RMA. So you'd hope we wouldn't be the first.
We have no idea. There won't be outline plans. In fact, the only things we'll have will be outline plans. In actual fact, I think, from what I read.
And management plans, lots of management plans. And I think, when Paul and I have talked about this, there's with it being Hamilton City versus Hamilton City, you would really expect there'd be a pretty good conversation. In my experience with our team working on Waikato Expressway, one of the key relationships is the planning guidance unit, where you're submitting massive multiple documents, and big management plans are big documents, and so having an open conversation and being able to have an upfront, what are we looking at here, and I think this talks to the change process as well, which we'll get to shortly, to be able to apply a bit of reasonableness to this and a bit of what is practical, what is actually, in order for a management plan to be useful, it can't be something that was prepared early on and never really picked up again, because it risks not being not being useful and current. So and to your point earlier about how is it all stitched together, I think Mr. Gumley answered the ULDMP, and hopefully I've explained it well enough in that diagram too. That document really will sit across all of them. So even though others are coming through at different stages, the ULDMP does, and the cultural monitoring, the cultural management plan will also help to maintain that look and feel for for lack of a better term, the look and feel of what the environment might look like out there and what we're trying to achieve. Okay. So we'll pick up again at 48. So the Section 42 reporting officer takes a different approach to the management plans, and the objectives are expressed differently in various levels of detail. For instance, the 42A reporting officer's proposed objective 23A for the ecological management plan is to incorporate, protect and enhance the habitat and biodiversity values of the receiving environments and open space adjoining the roading infrastructure. I disagree that these are the objectives of the project's ecological management plan, and instead suggest it is to manage the actual and potential effects of the project on the ecological values in accordance with the effects management hierarchy. These are the matters over which the RA has control and relates to the effects that the RA is seeking to manage through the implementation of the management plan. I also feel that this, the way it's expressed in the 42A report, risks overlap with the ULDMP, and that was touched on by Will as well. We have objectives and outcomes need to have a different focus for that clarity of implementation. So coming back to those principles of the conditions, if they are appearing in different places, then there's a risk that the implementation of them is blurred as well. And there's a couple of examples here where the proposed objectives by the 42A team really touch on a number. It could be picked up in a number of the management plans, and I think that's potentially risky, if you like. So I just picked that up again here at 50 as another example. Let
me just pause there, because I mean, we've been talking this morning all through, in actual fact, about the fact that this is an elastic time frame, and I think the point is reasonably well made that in actual fact, people who are going to be developing these plans are probably not sitting around this table now. They're going to be another generation of practitioners in many instances. So writing the script for them is probably as important or more important than writing the script for future consent planners or regulatory planners who are going to be assessing these things. It's something to have a think about, and again, let's chat tomorrow about that, because I think it underlines just how we go on it.
Yes. Okay. So at 50, I just use another example. So
The 42A reporting officer proposes 11 objectives in the ULDMP management plan condition at 24, which are very specific and, in my view, not outcomes focused. In some instances, they prescribe methods to achieve an outcome, such as providing the continuous tree cover or providing no net loss of lizard habitat. I do not support this level of specificity and instead consider the two urban and landscape design management plan objectives in condition 10 more reasonable and appropriate. And I've just got another example. I think the TA proposes an example objective here, 24A Roman numeral 2, to mitigate the construction compounds on residents. And so this is a good example, in my view, where the management of the construction compounds and screening is really a method. So it's quite specific, and it's a method that sits in the construction management plan. I don't at all believe that it's an objective of the urban and landscape design management plan at all, because construction compounds are very short-term, temporary, and the effect that you're managing is during construction, as opposed to bringing that screening of construction compounds into your urban and landscape design management plan. That just doesn't. That's quite a that's a scene-setting piece that informs how that part of the network will ultimately look and feel, rather than managing a temporary effect. So, don't want to labour the point, but that's where we got to, I think, with the management plans. So, picking up at 51, the management plan change process. So, condition 18D in the final conditions recognises that as a management plan is implemented, there may be changes in design, construction methods, or the management of effects. In my opinion, a good management plan is one that retains flexibility in its approach and can adapt to changes in a manner consistent with the management plan's objectives. As such, the condition provides for management plans to be amended without further process unless the change is considered material, and a definition of material change has been provided in the final conditions. By way of example, after submitting an outline plan or a management plan, in the circumstances that there is a change in the baseline information, any process, procedure or method of the management plan which has the potential to materially increase adverse effects on a particular receiver, a revised part of that management plan and outline plan would be submitted for review and comment. However, administrative, minor or inconsequential changes do not constitute a material change and would not require resubmission. So an obvious example of that is a contact person changing. You just wouldn't need to go there. However, I've tried to think of an example or provide an example where you might see a material change. And one that springs to mind is in the construction traffic management plan, for instance. We have a condition in there around site access routes and access points for heavy vehicles. So they may well change due to, let's say, an archaeological find might, impede the route that all the heavy vehicles come into site for. So changes to effects might be anticipated if you're changing your site access, for instance, and they may be dust, noise, vibration, access, both on nearby residences and on nearby businesses potentially. This, in my view, would prompt a material change process. And in looking through how that would play out in the management plans, it's likely that it would impact on a number of management plans, but only parts of them. So you would potentially then see a change to your traffic management plan, maybe a construction environmental management plan, noise, schedule, things like that. So just trying to give you a sense of the scale of difference that you might trigger a material change process through.
I'm puzzling this one over. I'm just looking at the definition. I just want to read the definition of material change. Okay, that's material change. That's different, isn't it? That's material change to a management plan, not the material change to a condition or to an effect. I mean, I guess what I'm puzzling with at the moment is how do we, in Rule 52, how do you determine issues, potential to materially increase adverse effects on a receiver? That seems to me quite a difficult.
So it's...
I mean, given that phrase to me, you'd have to err on the side of caution, which actually doesn't give you what you think, I think. I don't know if this appears in a condition anywhere, this phrase, but just have a think about that, because there are too many uncertainties in that construction to give you what you're looking for, which I'm assuming, and let's not worry about the words, but it's anything which is more than a minor increase, adverse effect. I know you don't want to use the terms, but I think that's what we're really talking about, aren't we? So anything that's not, that is minor or maybe even minor or less, you're saying we should be able to do it.
Yeah.
But I don't think it captures that there, so we might have a think about that again tomorrow.
So this definition has been provided from the Central CRL Environment Court decision, so it's been something this has popped up in other places. I won't take the credit for it.
You think that's going to impress me?
No, but it just so you know, it's got some legacy, and yes. It wasn't created by myself in the middle of the night.
Challenge accepted, right?
Yes, that's right. That's right. I'll see you in the High Court. Yeah. No, but
I just want to just engage on this point if I can. So obviously, what we're trying to achieve here is something that feels like a sensible balance between, okay, when do we need to report up, and when do we all just accept that we're not going to get sort of bogged down in the detail of something which is ultimately inconsequential. So it's about trying to strike a balance. And so what this drafting had attempted to do was define the moment where something gets reported up, obviously, and it was where there was a material change to base information which changed the management plans in a way which had the potential to materially increase adverse effects. So that's an effort to try and define a threshold, which is not dissimilar, I think, Mr. Hill, to the language I think you just started to articulate. So I think we're heading. I mean, I don't have a problem. My submission will be that the structure of this is probably heading in the right direction. It's just a question of how do you want it measured? What are the words that will,
And obviously you don't want to leave yourself open to third-party litigation on someone's got it wrong.
No, and yeah, I mean, it is inherent within this kind of condition that there are going to be some judgments made. But the hope is that between the TA and the RA, everyone is being practical and.
The obvious concern is just the transparency, because for the public, it's one organisation.
Yes. Well, it might, but that might be an important point. Is that the one thing that this doesn't deal with is how does a decision on materiality or immateriality get recorded and then reported back to stakeholders who might have an interest in that. I think that issue is probably something that's not currently addressed, which we should probably think about, as well as the wording. So we'll come back on that.
Okay. Right, so picking up at 54. The Section 42A reporting officer proposes changes to the suite of ecological management plans in conditions 22 to 23. I accept in part most of those changes, as is reflected in the proposed final conditions 29 to 35, with the exception of the objectives, as we've discussed already. The 42A reporting officer proposes lengthy changes to the suite of urban and landscape design management plan conditions. I disagree with those changes, especially the objectives as discussed earlier. In my view, the amendments provided in the proposed final conditions 10 to 12 appropriately manage the urban and landscape design effects and provide for engagement with mana whenua and Waikato Tainui and relevant stakeholders. Supplementary statement of evidence from Mr. Balbooth addresses the proposed amendments to condition 28 operational noise, and these changes have been incorporated in the proposed final condition 28. The remaining management plan conditions are largely unchanged from the revised conditions, except for minor drafting edits or the inclusion of additional provisions where these are agreed. I've just spelt them out there. Condition 36, outline plan. The Section 42A reporting officer proposes a number of additional matters that need to be provided in the outline plan process in condition 34 of the addendum conditions. Final condition 36 provides sufficiently for those matters to be addressed during the outline plan process, particularly matters that are already included in the various management plans, such as the record of engagement and the pre-construction ecological survey report. Final conditions 7, 13 and 14 already specify that compliance shall be demonstrated in the outline plan and does not need to be repeated again in 36. Demonstrating compliance with these conditions is a matter for the RA to determine and is not necessary for the TA to specify this in the form of a detailed design report or other specific assessments. Okay, response to tabled statements. Ministry of Education. I acknowledge the Ministry of Education statement dated 30th of July, and in particular their support for the engagement progress made between the Ministry and the RA to resolve matters raised in their submission. Proposed final condition 4 and 23 still feature in the changes sought by the Ministry. However, I do not support the Ministry's position in relation to condition 4 advisory note. As we've already talked about this morning, the Ministry does not have land designated under or adjoining the proposed designation that would be affected by the project, and as such they do not carry the same RMA section 177 status as KiwiRail and NZTA for this project. Should the Ministry wish to discuss development proposals for any land they may acquire adjoining the designation, the proposed condition 3, land use integration process, is sufficient for this purpose. Waikato Regional Council, I acknowledge the WRC's statement dated 11th of August 2025, in particular its support to address matters raised in its submissions. Since tabling the statement, the RA has engaged further with the Regional Council staff to reflect their wording in the proposed final conditions. This is now captured in condition 4A Roman numeral 2 in table 1, condition 13 and condition 23. The updated wording was confirmed with Waikato Regional Council staff on the 30th of September, and their updated statement has been received confirming that they are satisfied with the proposed final conditions. Moving now to statutory considerations. The Section 42A Reporting Officer's Addendum Report concludes at Section 6 that without amendment to the revised conditions, the project would be inconsistent with the provisions of a number of statutory instruments laid out in Sections 5.3, 5.6 to 5.9 of the Addendum Report. The provisions identified in these sections mostly relate to the effects of the project on the ability of mana whenua to exercise kaitiakitanga in the development of the project. As discussed in paras 14 through to 24, through recent hui between the requiring authority and mana whenua and Waikato Tainui, the parties have confirmed their intentions to build on the existing relationships and progress this project in partnership. This has meant taking the time necessary to co-author the conditions with mana whenua, resulting in support and alignment with the RA's proposed final conditions as expressed in the statement of Joe Kukutai this morning. For completeness, Table 2, Policy Response to the Addendum Report, provides an assessment of those matters identified in Section 5.3, 5.6 to 5.9 of the Addendum Report. I consider the updated assessment suitably addresses the matters raised by the Section 42A Reporting Officer. I consider that the proposal is consistent with the relevant provisions of Te Ture Whai Mana, the National Policy Statement for Indigenous Biodiversity, the NPS on Urban Development, the Waikato Regional Council Policy Statement, and the Hamilton City Operative District Plan and Part 2 of the RMA. Conclusion. The revised conditions proposed in my primary evidence are founded on strong principles derived from Te Tupu Ngātahi supporting growth and represent a good foundation for this project. The proposed final conditions and supplementary attachment bundle 3C build on this drafting foundation. Since submitting the revised conditions through evidence, further engagement has been undertaken with mana whenua and Waikato Tainui and submitters. The outcome of this engagement is reflected in the proposed final conditions. Where amendments proposed by the 42A Reporting Officer result in improvements to the revised conditions, I've incorporated these. In other conditions where I disagree with the principle behind the proposed condition, or there is a difference in drafting preference, I have not brought those changes across. The RA is committed to working in partnership with mana whenua and Waikato Tainui on this project, and those conditions enable mana whenua to exercise kaitiakitanga over those aspects that have special interest to them. And the RA is also committed to working with the various stakeholders and submitters who are not here today, but which in my view shows the good faith that the RA has built with the parties, first through the revised conditions and then the proposed final conditions which respond to their needs. I remain of the opinion the designation is reasonably necessary to give effect to the project objectives and is consistent with the various statutory instruments that influence the development of infrastructure in this greenfield location. Subject to the imposition of the proposed final conditions, I'm also of the opinion the project is consistent with Part 2 of the RMA and that the designation should be confirmed on this basis. Thank you.
Thank you, Ms. Latter. I've been asking questions all the way through, of course. I'll let Mark have a go. Just before that, just a practical issue for me. I mean, when you look at Condition 36, which has all the management plans which are required to be submitted with the outline plan, and of course 176A only gives the territorial authority 20 working days to actually make requests to change. I suspect that's not going to be practicable. How do we deal with that? Is that just, you just don't worry about it and just get on with business, or is there an ability to add a longer time frame in here over and above the statute? Mr. Modani, have we got an option here, or does the council have to rely on 37 or something like that to extend the time frame? Because I mean, I just don't see the council, that side of the council being able to respond in 20 working days for the raft of things that are likely to come forward. Just a practical matter.
I will reflect on that. My thinking is that you could formulate a condition which is drafted in such a way as to require it to be, in effect, give yourself a longer period.
I mean, again, it's just one of those things to avoid an issue later on that somebody just gets excited about. That's all. I mean, I've never understood why there's a time frame in the Act anyway, but it is in there. So. And
yes, I'll reflect on that.
Yeah. Mark.
Thank you. At several points along the way today, we've talked about the dependency and relationship between the Greenway and this designation. And I see, and I know the construction of the condition in the RA's condition 1E is a little different to what was proposed in terms of this condition referring to the relevant section of the Rotorua Greenway as opposed to the Greenway having been completed. And I'd like to understand the reason for that distinction.
Yeah, so 1E as it's currently drafted now suggests that because the Greenway will be constructed in stages, that it's completely impractical to expect that the Greenway is completed, it's completed and operational before giving effect to the construction of the arterial. So we're more comfortable with the parts of the Greenway that are relevant to that part of the arterial being constructed in advance, and it may not be open and ready to receive all the water prior to this being completed, but having the ability to say the relevant section of the Greenway shall be completed and operational, ready to receive the water before that part of the designation discharges the stormwater into the Greenway becomes operational. So it's about picking out the parts that are relevant, because essentially what we're seeing at the moment with Hounsell is that they're starting in the southern part of the Greenway, if you like, and you'll see this when you're out on your site visit tomorrow. They're underway in the south, but in order for that part of the network to be operational, they actually had to get and construct a good chunk of it up to Lake Rotorua. So they're going to be moving along that Greenway in order to enable their part of the network to be discharging in it. So, but then there's parts of the Greenway to the south that aren't going to be affected by various parts of the Greenway, particularly if you're looking up in the northern part there. So where the cursor is at the moment, there are parts of the network that won't discharge to the Greenway. So they're not captured by this condition. You can actually get going on other parts of the network because they're not discharging into the Greenway. So it's really about making sure we're picking up those relevant parts that are discharging to the Greenway and that the Greenway is ready to receive the water prior to the roading element being completed and discharging. So it's hopefully.
So does operational there mean ready to receive water effectively, does it?
Yes.
And that's clear?
Yep.
Yeah, okay. Just whilst Mark's thinking, it might be helpful to us, or certainly would be helpful to me, if we could be provided with a copy of the consent conditions for the Greenway. I mean, I hate to do more reading, but I think it might be useful just to understand how that is structured. Or
consent conditions or designation conditions?
I've got no idea what I'm asking for. I'm a bit nervous about asking for it, but I mean, it'll be a big document. That I'm quite confident, but I don't know what I don't know about the connection, and the connection's so important that I think we should probably. I don't know whether somebody wants to give us a presentation on it. That might be another quick way of doing that.
Yeah, we will think about that overnight, because it may be that we see if we can get the relevant person from within Hamilton City, who's effectively the project sponsor, to at least be able to come and perhaps answer some questions, some sort of basic questions that you might have. Yeah. That could be one practical way through. Yeah. Otherwise, we're starting to try and draft a statement without quite knowing what. I know. So we will test that availability overnight and see if we can find someone that's around. In the meantime, we'll also drag together the relevant designation conditions and fast-track consent conditions all in one place.
Okay. I mean, Mark, you make me very familiar with the Greenway, the detail?
No, I'm not.
Good. So we're both in the.
Right. But it was just for confirmation. The particular question I had related to the conditions that appeared to be had the potential to become mutually exclusive. Was I understand, because it was referenced in some evidence from someone in here, 42F.
Yeah. So it's in my primary evidence on page 44 at paragraph 43F. No, paragraph 86F, and we've actually got the excerpt of that condition below it, condition 42F. But I sort of stepped through the interpretation of that condition, because it was raised in the Newitch submission, and they were seeking some clarification as to why we weren't providing for that overland flow path within the Rotorua corridor, the arterial corridor. And so, as explained by Mr. Smith, physically there's difference in levels, but I guess the second point from our perspective is that is a condition that sits in the Greenway set of conditions, if you like, and so for us to the extent that it requires the requiring authority on a different project to implement is incorrect. While it makes reference to some consideration should be given, it's not incumbent on us to be managing overland flow path from a different designation. Notwithstanding, it's the same person, it's the same as Hamilton City, but there are different designations, there are different elements to pick up. I suppose the other thing to note is the overland flow path from the Greenway does spill out onto a property who aren't a submitter in the Godley Marsh was the submission that covered the property. They weren't the owner though, and in time when that property is developed, that overland flow path will need to be picked up and addressed then, because at the moment when that culvert blocks in the overland and the Greenway overtops, the overland flow path just floods the whole paddock. It's so flat out there, it just floods and so in order for them to master plan their site, they will need to have a place for that overland flow path to go. So there'll be a process of engaging with Hamilton City as the RA for the Greenway and the developer to deal with that overland flow path, but it's not sitting within the arterial designation. There are a couple of other little matters that came through.
Sorry.
Oh,
Does it make sense, or do you want to clarify?
It does make sense. Yeah.
Okay, all right. Okay. Slow?
Oh, there are a couple of other little matters that I've been picking up as we've been going. So I wonder if, just to loop back, Commissioner Hill, to your question around the designation boundary of the wetland that Hounsel, the wetland that we've changed, and you were asking about whether it was the consented boundary versus the designation boundary for Hounsel. Essentially what we've picked up is the boundary that reflects the consent. So there's no margin, if you like. We haven't applied a buffer or a margin that we might typically apply in other wetlands, because usually that margin is to enable room for construction, a little bit of a more footprint for detailed design in case we've got some unders and overs. In this case, the wetland footprints that Hounsel have been progressing are at a really detailed design stage. They will be constructing it within land that they own around it already. So by the time it gets vested in the RA, it's really got a very defined boundary, and that's the boundary that we've reflected. I guess worst case scenario, in the event that there is a change in the footprint, that would be picked up during the rollout, or the roll-up, if you like, of the designation, because Hounsel is also the landowner of the land around the wetland. So if we could either get an alteration to designation if we needed to with their agreement, because they're the party, but best case, we've got a footprint that is reflective of their consented wetland that they will get underway and construct and vest. So we haven't included the buffer, if that.
Why wouldn't you simply go to their designation?
They don't have a designation.
Oh, they don't?
No. So then they haven't designated it. So we laid the designation out first day. They came along with their consents, and then we've adjusted our designation boundary to reflect their consented footprint.
Right, right.
Okay, so that's that point. Another point I picked up earlier is in your opening, you made reference to Te Ture Whai Mana being properly recognised in conditions. And so we haven't explored that much more, but I wonder if I could just offer how I see Te Ture Whai Mana coming through in this project. So I think for us, Te Ture Whai Mana is a fairly well embedded concept now. It's well established. The vision and strategy is very, very clear in the cascade of legislation. And I think it would be fair to say it's within the DNA of the project. In my experience of working with projects, other Hamilton City projects, the partnership with mana whenua is really strong, and the Waikato Tainui reps in particular, Te Ture Whai Mana is almost the first word that comes out of their mouth whenever we're having a hui. Te Ture Whai Mana is very front and centre, and so I feel rather than looking for a condition that might specifically say, here's all the things you need to be considering for Te Ture Whai Mana to give effect to Te Ture Whai Mana, is that it's inherent in the project. I mean, if you're looking for that condition, there is reference to it in condition 9, but the project has Te Ture Whai Mana embedded in the principles and in
You're
the
saying
objectives.
it's the vibe.
It's the vibe. It is. Yeah, it really is. And I think you can see it in the way Hamilton City works very well and closely with Waikato Tainui. It's very clear, they don't stray far from the course around anything to do with Te Ture Whai Mana. So, yeah, it's the vibe.
We'll see if we agree with you in due
Okay.
course.
I think that's probably the key points I've picked up.
Okay.
Yeah.
Actually quite good, maybe.
You good?
Yeah.
Thank you, Mr. Taylor. I mean, we'll pause on the conditions thing, obviously, for tomorrow's conversation with council.
I'm just advised, apparently Mr. Balbooth has got some matters that he can come back and clarify for you now. So if it's convenient, let's recall him and get that dealt too.
You guarantee it's a clarification?
No.
Mr. Balbooth, yeah.
Our best endeavours.
Yes. They pull the wool over your eyes all the time, eh? Yeah.
Acoustic wool. At least it's absorbative. Thank you for the indulgence, and apologies I couldn't put my finger on it earlier. I understand you asked me what the numbers were for the different categories. Yeah, so the information is in section 325 of my original A&E.
Yeah.
It outlines the 3 different categories. There are different levels for new roads and altered roads. So I'll deal with the altered roads first. There are 3 PPFs that are on the altered road, so it gets the first cab off the rank. Category A is anything below 64 decibels.
Yeah.
Category B is anything below 67 decibels. Category C for both new roads and altered roads is when you can't get below 67 decibels, you aim for an internal noise criteria, and they are both 40 inside.
Yeah.
To put it into context, I understand you're interested in this to appreciate how far away we are from that. For those altered road PPFs, that's 12 to 14 decibels away from getting from Cat A to Cat B. So there is almost absolutely never going to change.
Yeah.
For the new roads, the criteria for Category A is anything less than 57, and for Category B, it's anything less than 64. Again, Category C is an internal if you can't achieve 64.
Yeah.
For our one new road receiver at 2729 Burbush Road, a shift into Category B is 3 decibels away.
That's not much.
Not much, so it's not probable, but it is possible. Hence why we've included this Roman 20 and Roman 30 as a pathway for best practicable option.
Because I mean, we won't know obviously until the things are built and traffic's moving, and then you'll take an assessment, presumably.
Yes, detailed design. There's all sorts of phases to go through.
Yeah. That's helpful.
So can I just jump in at that point? When you talk about 3 decibels being not much, it's nothing's linear though, is it? So
no,
the measurement of noise
it's
is linear. It's a
an
substantial increase in noise.
It's a noticeable increase by most
noticeable.
things. It is a noticeable increase. Yeah. But I mean, that depends on the current numbers being accurate when there are any predictions. That's really the point I was making. Is we don't. I mean, they may be well below that. So no, thank you for the caution. Yeah.
Thank you, Mr. Belboth. How do we go? Clearer?
Yeah, not bad. You know, I'd give them 43 decibels out of 50. I think I'd give them. Right.
Well, that I think completes the evidence for now. There's a couple of matters that I just wanted to deal with. So the first is just in relation.
Just to jump in, I've had a conversation with Mr. Ryan, and Mr. Ryan, would you want to just characterise where we got to on that, or where you've got to subsequently?
So later this afternoon, we'll be releasing some statements from the specialists who have prepared very brief memos identifying recommended amendments to the final conditions.
Can you give us a time for that? Is that going to be by 5 o'clock, or is it going to be after 5?
Probably about then. Yeah. Well, what I've got to do is to make sure I've got the right version of the document, PDF it, then send it to Mary, who will then distribute it.
Oh no, she's really efficient. Yeah, that won't take any time at all. Once it hits Mary's inbox, it's out. Yeah, I just don't. I want these guys working till late. So. Yes. No, reasonable hour. That would be really helpful, Mr. Ryan. And
my own one, I'm still working on that, and that will be later. And in the worst case, it may be tomorrow morning. That's
well, if you could try and circulate that before midnight, that would be helpful. Yeah. Okay. Mr. Martin, does that help?
Not really. I mean, I'm still left in a position where I'm going to turn up tomorrow morning and I still don't have any real idea of what the planning recommendation is. I mean, I can get these expert reports this afternoon, but again, these are subject matter experts that are now reaching into drafting conditions, which is a planner's job, so I'm really not quite sure what efficacy these expert briefs will have. I'm more interested in the planner and the planning input into the drafting of conditions, which, as I understand it, I won't have until tomorrow morning. So it is what it is, that's fine, but I'm just, you know, you asked the question, I'm being frank with you.
Yes.
That's where I sit. So that's...
I mean, the only thing that we can offer in that regard is that we are only having Mr. Giles in the morning before we do our site visit. That site visit, Mary, what's the timing on that? Are we thinking a couple of hours, or what are we thinking?
I think a couple of hours is...
Yeah. So, I mean, I guess that's a space
That's
for...
a space, yes, so that's helpful. So
and if we need to then continue an adjournment for that conversation to conclude before we resume, we can do that because it's just us.
Yes, I mean, I'm conscious of trying to be efficient here, and I think we should work as hard as we can to avoid an adjournment or some kind of delayed...
And I mean, I'm happy for us to sit here for... I mean, we have the day, so
yes,
if
so
we need that, we'll take it. So
yes, I'm grateful for that, sir.
Yeah.
We'll take account of that. Well, that really covers off the first point that I was going to raise, which was just how to deal with the practicalities of the condition drafting. The only other point that I wanted to raise was just a housekeeping matter in relation, and it actually does come back to this presentation by Mr. Giles this morning. So in the bundle of documents that we have been referring to, and I'll bring them up if I can, there was the internal site movements on the 40 Te Kowhai Drive site, and I'm conscious that some of those images had been previously provided to the 42A team, so the TA has them, but I don't know that they are formally part of the record, and I would like them to be so that Mr. Giles has an opportunity to see them and comment on them tomorrow. So if we just scroll through the documents that I'm referring to, there's, I think, about how many images? 5 images that I want to just work through. So we just go to image number 1. So that's an image of the current traffic movements, and then if we scroll through the next one, just one at a time, that's showing the amended access way and some internal site trafficking movements for heavy vehicles. Option 1A, I think that's described as, and if we keep going, there's more, and we keep going. Again, these are all options around how the internal tracking movements could work. So my understanding is that these have sort of been discussed in general terms with Mr. Giles and the representatives from Sapphire during some of those pre-hearing engagements, and there was an iteration of these. It's not exactly the same, but it's very similar. These are sort of more formally drawn. So these shouldn't be new to Mr. Giles, but my preference would be, could we introduce them formally into the record and maybe have them up on the website overnight, and perhaps, Mary, you could arrange to ensure that Mr. Giles sees these today so that by tomorrow morning he knows what he's looking at?
Absolutely. And can we just go back to the first one there, because the thing that strikes me immediately on the first one is that if you just move up, is that in actual fact the existing track is very close to all of those options. So the tracks are actually being used at the moment, which is not something which I'd anticipate, I'd recognised before seeing that. So that first one is actually quite helpful.
Yes.
Yeah. So Mary, if we can do that, that would be good. Certainly we'll take that on the record. Yeah. That's it.
Thank you, sir. That's it.
Right. Well, thank you, everybody. Unless there's anything else, we'll adjourn now till tomorrow morning at 9 o'clock? Yes, 9 o'clock. Thank you.
Thank you. Tell her she needs to separate that stuff out for Mr. Giles. He'll need to sort of